As we have a quorum, the committee is now in public session. I want to welcome everybody back and wish everybody a happy new year and all the best for 2014. I want to welcome the Minister and his officials to this meeting today and the people in the public gallery who have come in to observe. Apologies have been received from Deputy Anne Ferris. I would now ask that all mobile phones be switched completely off, totally off please, not just it's on silent, or else put them a good bit away from the mic so they don't interfere with the sound system, because it's not fair on the officials who have to listen in and monitor and try and record what we're saying. So all mobile phones totally off, please. Thank you. Can I get agreement that sitting arrangements for this meeting would be from 10 a.m. to 1 p.m. and a break then, and resume again at 2:30 to 6. Is that agreed? Agreed. Okay. Could I also ask everybody to make your observations and questions so on through the chair? Also, I would ask people to keep your interventions as concise and as precise and as focused as possible on the amendments we're dealing with or the sections we're dealing with. Try not to ramble off into other areas. I will be as helpful as possible in reminding people of what we're about, focusing on the amendments to hand and the sections that we're dealing with. So we will now begin on section 10, amendment 36. 36 and 37 are related and will be discussed together. These amendments are in the name of the Minister. The Minister to move.
Thank you, Chairman. I so move. Could I, as this is the first meeting of the new year, without being accused of rambling, could I just wish all members of the committee a happy new year? Now, to directly deal with amendments 36 and 37. Amendment 36 is a minor amendment, the primary aim of which is to ensure that the authority begins to meet promptly after it becomes established and does not become moribund at any future stage. Amendment 37 is a pragmatic one designed to ensure that the authority does not become hamstrung by an inability to ensure that there is always a majority of lay members at every meeting. I feel that it provides a better balance than the original provision, which requires a lay majority of 3 at every meeting.
Okay. The question is that the amendment be made. Is that amendment 36? Is that agreed? Agreed. Amendment 37 already discussed with 36. The question is amendment be made. Is that agreed? Agreed. Amendment 38. Name of the Minister. Minister to move.
Yes, I so move, Chairman. This amendment removes any ministerial involvement from the determining of when and where the authority should first meet. The chairperson will determine this alone within 3 months of the authority's establishment day. This is another one of many amendments I'm tabling to protect the independence of the authority from ministerial influence and from any perception of any nature whatsoever that there will be ministerial influence in the day-to-day workings of the authority.
Deputy McGrath.
I just want to say that, first of all, I want to join yourself, Chairman, and welcome everybody back and wish everybody a happy new year. Just want to say very briefly that I welcome this amendment, and particularly in relation to the independence of the authority. I think that's a crucial thing.
Okay. Nobody else? Okay. The question is that the amendment be made. Is that agreed? Agreed. The question now is that Section 10 is amended to part of the bill. Is that agreed? Agreed. Section 11, amendment number 39, the Minister. Minister to move.
I so move. This amendment is a technical drafting amendment, which I'm told by Parliamentary Council is necessary.
Okay. The question is amendment made. Is that agreed? Agreed. That Section 11 is amended to part of the bill. Is that agreed? Agreed. Section 12, Amendment 40 in the name of the Minister. Minister to move.
This amendment, again, is a technical drafting amendment, which is recommended by Parliamentary Council.
The question is, it been made. Is that agreed? Agreed. Section 12, Amendment 41 in the name of the Minister. 41, 42, 43, 66 and 69 inclusive and 74 are related and will be discussed together. Minister to move Amendment 41.
Sorry, Chairman, I had another group of amendments here. Which amendment are we into? Sorry, which amendment, Chairman, are you taking then?
Yeah.
Oh, sorry, yes, Amendment 41 42, etc.
Yeah. 43, 66, 69,
Yes, sure.
and 71.
The proposed amendments to Section 21 and Section 27 are part of a suite of amendments, again aimed at removing ministerial influence or any perception of ministerial influence being exercised over the authority, while retaining a role for the Minister for Public Expenditure and Reform with a view to helping to control the costs of the authority, which are to be recouped via a levy on legal practitioners.
Okay, and you going to just refer to the other amendments as well together, or?
Sorry, Chair, I'm just trying to. Yeah, yes, I think that covers all of it, Chairman.
Okay, thank you.
Because I was dealing succinctly with, if you look at each of the amendments, you'll see they each deal with the giving of various ministerial consents for a variety of issues. They reflected the standard architecture of a lot of other bodies in the legislation that existed when the original bill was being drafted. And it was never the intention, or certainly was never my intention or the government's intention, that this would be a body in any shape or form controlled by the Minister of the day. And as you know, there were concerns that that perception developed, and each of the various amendments deletes reference to the authority requiring a variety of what are clearly unnecessary ministerial consents, which gave rise to the wrong perception.
Okay. Nobody coming in on any of those. Okay, then, Amendment 41. The question is that the amendment be made. Is that agreed? Agreed. That Section 12 of amended stand part of the bill. Agreed? Agreed. Amendment 42 on the name of the Minister. Already discussed with 41. Amendment Minister to move.
I move.
The question is that the amendment be made. Is that agreed? Agreed. Amendment 43 in the name of the Minister. Already discussed with 41. Minister to move.
I so move.
The question is that the amendment be made. Is that agreed? Agreed. The question now is that Section 13 is amended stand part of the bill. Is that agreed?
Agreed.
Agreed. Now, Section 14, the section proposed to be deleted. Minister.
Yes, I propose, Chairman, that the section be deleted. The Department of Public Expenditure and Reform has requested that Section 14 be deleted from the bill as it duplicates provisions contained in the Ethics in Public Office Act of 1995. The authority and tribunal will fall within the scope of the 1995 Act, the first schedule of which, in Section 1, subsection 12, provides that a body, organisation or group appointed by the government or a minister of the government constitutes a public body for the purposes of that Act. So apparently this section isn't necessary.
Okay. Now, I'm putting this question that Section 14 should stand part of the bill. And is that agreed?
No. I don't think that's the question. I think the
question, the question is that it will stand. No, sorry. The question is that it will stand part of the bill, but the answer is expected to be no.
I think the question probably means should the question be deleted, but no is the answer.
Okay. Is that agreed?
So it's a rather obtuse way of dealing with it.
Okay. Anyway. Question is lost. Okay. Now over here. Right. Section 15, Amendment number 44, in the name of Deputy Collins. 44 and 45 are related and will be discussed together. Deputy Collins, to move.
Yeah, I move, Chair. The concern here is around confidentiality and privilege of information and documents, so I move the amendment.
Minister.
Firstly, Chairman, can I say that I'm aware of concerns that have been raised in relation to this particular section. I am, however, opposed to this amendment. While I am happy to consider any concerns the Deputy may have about aspects of Section 15 of the bill as published, I am still considering this section, along with Section 17, in response to concerns that have been expressed by the Law Society. I will therefore revert to this matter at report stage and be guided by the views of Advisory Council, and I think it's likely that we will be amending the section at report stage. The proposed government amendment number 45 is, I'm told by Parliamentary Council, an appropriate amendment to the section by way of comprehending the applicable ethics in public office legislation. I understand we're discussing 45 with 44, which is why I'm referencing that. But I want to assure Deputy Collins that we're going to come back to this section and also to section 17. It is of importance that information relating to clients has the appropriate privileges extended to it, and that matters that should not be disclosed are not disclosed, but there are other issues in relation to the section that need to be considered. So we'll come back at report stage.
Deputy Collins, you're happy with that? Deputy Doc, you want to come in? Yep.
It's on the same issue that Deputy Collins has raised. Minister, to be honest, I can't understand why we're almost 2 years into this process. This was in the initial bill that we have. It's staring out us in the face in relation to client confidentiality. The issue, it goes to the very core of the relationship between the legal fraternity and indeed our whole justice system, and that it hasn't been dealt with at this point, and it does cause concern. And your assurance that it may be addressed or it may be amended at report stage, I would just be frustrated that here we are 2 years down the road, something that is staring us in the face that should be amended to reassure everybody, and we don't have an amendment from you here today. So I hope Deputy Collins pushes the matter. I'll certainly support him in doing it.
Sorry, just one, Ryan, but if members would address remarks to the chair.
Apologies, Chairperson. Yeah, no,
thank you. Minister, you want?
Well, I'm sorry to hear about the Deputy's frustration. The purpose of committee stage is that we tease out issues in relation to this legislation. In the framing of amendments, we've had particular regard to submissions received from various groups and organisations, and that there are technical issues in relation to this section in section 17 that Parliamentary Council required further time to deal with, and I was anxious that we progress committee stage. This bill has been unduly delayed as a consequence of the pressures on the Attorney's Office arising out of the legislative programme prescribed by the Troika and the need to enact and put in place the insolvency legislation. I would have preferred that we would have been taking this committee stage at least 12 months ago, and that didn't prove possible. And I'm conscious, and as we go through the bill, as we're going through committee stage, I will be putting down markers to members of the committee that there are some issues that we haven't yet finalised on a technical level that we need to deal with, that we will be coming back to at report stage. This is one of them. And some of them are issues that have been raised some time ago, but the reality was that the technical work that was necessary to be undertaken could only be undertaken in recent months, not only since the insolvency legislation was complete, but there were issues around all of the additional rules and regulations that had to be made in respect to the legislation, and fulfilling a promise that I made at the time of its enactment. It was an enormous piece of legislation, and it was inevitable that some issues, once it was up and running, would arise in practice that could create technical difficulties, and we have, as the deputies will know, with great speed addressed any issue that's arisen in the workings of the legislation, and that, of course, has taken the time of the same Parliamentary Council. So I'm personally frustrated that this legislation wasn't fully enacted and enforced by now, and I can empathise with the Deputy's frustration, but I can assure the Deputy, as he knows well from his experience in dealing with me, if I say we're going to come back to an issue and address it, we do come back to an issue and address it, and all of the focus now is on having this legislation completed with any changes required to ensure we have the best possible piece of legislation in place, and to iron out any glitches or issues that need to be ironed out. And that's the purpose of my saying that we will come back to this, both this and section 17, at report stage.
Okay. Deputy McGrath, you want to come in?
Just in relation to section 15, I'd just like to say that I have major concerns as well in relation to this particular issue. And while I understand the technical problems that the Minister has and the Department has the time. I think it's very, very important that this issue be addressed. I don't know whether the Minister said earlier on in his comments it may be addressed. I look at it, but I mean, I think we should be looking from a serious commitment today from the Minister to actually deal very strongly with this issue, because despite our political differences in relation to the Legal Services Bill, we all support the idea of independent regulation. We all want to improve access and competition for competition. We all want to make legal costs transparent, and we also want to deal with the consumer complaints issue. So what I'm saying to the Minister is we don't want any maybes or ifs or buffs or his sharing his frustration. I think he should give a commitment today that this section will be dealt with very strongly.
Well, just to briefly respond to the Deputy, I think it's important to point out, for emphasis of context, that Section 15(1) of this bill that we're dealing with is a safeguard provision prohibiting the disclosure of confidential information obtained in the performance by specified persons of their functions on behalf of the regulatory authority. The thrust of the entire section is therefore to prohibit unauthorised disclosure of information. But it is important to retain certain instances relating to the commission of indictable offences. And I know Deputy Collins has raised this issue in good faith to allow us to tease it out, and I'm sure it wasn't his intention to delete the entirety of the section, because if you look at Section 15(1), the start of it says, as otherwise provided by law, etc., a person shall not make information available. Well, in one of the areas in which information can be made available currently is if there's money laundering being engaged in. There are strict obligations in relation to money laundering, the strict obligations with regard to informing on Garda Síochána, the strict obligations which allow matters to be investigated. And these are one of the exceptions to circumstances in which the privacy of a solicitor's office may be invaded, an investigation conducted. So there are exceptions to the rule of privilege, and they have to be taken account of, and I'm sure members of the committee, all of you, would agree that that's the case. So this is why, in the context of concerns, and I think they're reasonable concerns that have been expressed, that the manner in which some aspect of the section is framed could give rise to concerns that it goes further than is intended, it has to be reframed. But this has to be done very carefully to ensure that where indictable offences are being committed, for example, by a member of the legal profession, that the matter can be fully and properly investigated. And the sad reality is that we have had indictable offences committed by, and some members of the legal profession convicted and imprisoned for committing such offences. So this is a section which is actually designed and intended to be a protection for clients, whilst ensuring that where there is serious criminality, it can be properly investigated. And I do agree that there's an issue of looking again at this section, and Parliamentary Council is already doing this, but we were not in a position to have the appropriate amendments circulated in time for these meetings, and we will come back to it.
You will come back to it at the fourth stage. Okay then, Deputy Collins, how stands Amendment 44?
Yeah, I'm going to press the amendment, Chair, and just ask, I'm noting what the Minister is saying in relation to his intention for report stage. The earliest publication possible of your proposal for report stage would be very helpful, because it is very important, and it's right, we have to get the balance right as well, because I'm hearing what you're saying in terms of money laundering and that aspect of it, and trying to balance between privilege and confidentiality, plus our obligations under money laundering to try and root out criminality on that side. Just if we could have it as early as possible, because it is something which is going to be contentious and sensitive. Okay. So I'm going to press the amendment.
Okay.
Thanks.
All right. On amendment number 44, the question is that amendment be made. Those in favour say Tá.
Tá.
Those against say Níl. I think the question is lost. Amendment lost. Amendment number 45, already discussed with 44. Minister to move.
I so move.
The question is the amendment be made. Is that agreed? Agreed. The question now is that Section 15 is amended to stand part of the bill. Is that agreed? Agreed. Section 16. Amendment number 46 in the name of Deputy McLaughlin. Acceptance of this amendment involves the deletion of Section 16 of the bill. So we're proposing a new section. Now also, Amendments 47, 53 inclusive are alternatives to 46. 48 is an alternative to 47. 51 and 50 and 51 are alternatives to 49. 53 is an alternative to 52. 46 to 53 inclusive will be discussed together. Deputy McLaughlin to move.
Okay, thanks, Chairman. This amendment is in the spirit of the amendment you've made yourself, Minister.
Sorry, through the chair, please.
Oh, okay, Chairman. It's sort of strange because you're asking the Minister to consider agreeing with you, but you're speaking to somebody else. But
yes.
Anyway. Okay, Chairman, you're a nice guy. I'll speak to you.
You can talk to me about the Minister. Okay?
Is this good cop, bad cop? So I speak to the good cop. Okay. In relation to yourself, Chairman, address yourself. In relation to this amendment, it's in the spirit of the earlier amendments that the Minister has put himself, which is trying to clearly demonstrate the independence of the authority. So rather than the Minister being accountable to the Minister, that is accountable to the Houses of the Oireachtas and specifically to this committee or any other committee that might replace it down the line. That's the intent of the amendment. Thanks, Chairman.
Thank you, Deputy Minister.
Well, just to the Government Amendments 47, 49 and 52 are part of a suite of amendments aimed at removing, again, any perception of ministerial influence over the authority by way of a required consent or otherwise in relation to the matters concerned. The new provision also refer to the joint committee instead of the Minister, and I think effectively achieves the objective that, that the Deputy is seeking to achieve.
Okay. Right, Deputy McLaughlin, how stands the amendment?
Just to clarify, Minister, what you're saying is that you...
Sorry,
got to get used to this.
Well, you're trying for a while.
Okay, Chairman. In relation to it, basically what I'm asking is the Minister suggesting that that he is dealing with this matter in his own amendment? Is that what he's saying?
Minister.
That's what I'm saying, and the body will report to the Joint Oireachtas Committee, not to the Minister in the manner in which it was originally framed in the bill. Again, I come back to the point, there was all sorts of interesting and exciting motives attached to the way we approached this originally, and the way we approached it simply was based on the precedent of other similar bodies. And as the Deputy knows, concern was impressed that either myself or some other future Minister for Justice, in a fit of insanity, might want to control the entirety of the legal profession. This is designed to ensure that the message goes out based on the principles already specified and enunciated in the bill from day one, that the independence of the legal professions are important, the independence of this body is important, but this body must be accountable to somebody. It can't be free-floating and not accountable to anybody, and therefore it's accountable to the Joint Oireachtas Justice Committee in the context of reporting to it on issues of concern, and the committee can if need be, engage with that authority, but not in any shape or form and or any manner that would in any way impact on the independence of the legal professions, nor on the very important principles prescribed in the bill, which underwrite the approach to be taken by the regulatory authority.
Okay. Deputy McLaughlin, sorry, do you want to finish?
No, it's somebody else wants to come in.
I just want to support Pádraig McLaughlin's amendment because I think it's a very important one. And I think that also there's two issues within that amendment there that are very important, and also in the week that's in it. First of all, the strategic plan for the 3-year period, but also the word dealing with the objectives, the outputs and related strategies of the authority. I think that's a very important one. And the third point I make in section C is the efficient use of the authority's resources. I think these are key sections within that amendment that, in light of the use of public money and the debate in the last week or so, I think these are important amendments. So I strongly support Amendment 46.
And just as you have the floor, Deputy, your name is attached to a number of other amendments there, as you know. Your name is attached to a number of other amendments that we're also discussing at this time, just to be helpful, as is Deputy Collins.
Thank you very much.
Deputy Collins, do you wish to come in there?
Yeah, I have nothing really further to add. I think we're all on the same page.
Okay.
So.
All right.
If I could just point out to the Deputy, as I've said already, the amendments I'm proposing address the issue. If you look at section 16(1) in the bill as originally framed, it reflects all of the language in the amendment proposed by the deputy insofar as it is necessary to do so, but that the suite of amendments that we're proposing address the matter in an appropriate way. So I would suggest to the Deputy that there isn't a need to move his amendments because we've dealt with the matter, but obviously he's free to make his own decision as to whether he wishes to do so or not.
Okay. Right, Deputy McLaughlin, how stands the amendment?
I'm just double checking that what the Minister's saying is absolutely correct. Just give me 2 seconds, please.
Yep.
Okay, withdraw the amendment.
Amendment number 46 withdrawn. Okay, amendment. Now, okay, we'll go through these. So the next one now is Amendment 47 in the name of the Minister. Minister to move.
I so move.
The question is that the amendment be made. Is that agreed? Agreed. Amendment 48 now cannot be moved. Amendment 49 in the name of the Minister. Already discussed with 46. The question is that the amendment be made. Is that agreed?
Agreed.
Minister to move.
Agreed. I so move. I so move.
Right. Okay. The question is the amendment be made. Is that agreed?
Agreed.
Agreed. Okay. Amendment 50 cannot be moved now. Neither can Amendment 51. Amendment number 52 in the name of the Minister. Minister to move.
I so move.
That's already discussed with number 46. The question is the amendment be made. Is that agreed? Agreed. Amendment 43 cannot be moved. 53, sorry, cannot be moved. Yeah. Now, the next thing is the question is that Section 16 is amended as Stamp Bill. Is that agreed? Agreed. Section 17 now, amendment number 54 in the name of Deputy McLaughlin. Acceptance of this amendment involved the deletion of Section 17 of the bill, so we're talking about a new section here. Amendments 55 to 59 inclusive are alternatives to 54. 57 is an alternative to 56. 59 is an alternative to 58. 54 to 59 inclusive will be discussed together. Deputy McLaughlin to move.
Thanks, Chairman. Similar to the previous amendment, this is intended to strengthen the independence of the authority as seen in the public eye and to remove any suggestions of the Minister directing or any of that and to just purely have it accountable to the Oireachtas. So that's the intent. There's one particular phrase in the existing bill, as the Minister may direct, that type of language is to remove that type of language from the existing bill and have it accountable to the Oireachtas.
Okay. Minister.
To the similar issue. Government Amendments 56 and 58 are again designed to remove any perception of ministerial influence or any real ministerial influence over the authority in relation to the matters concerned and cite the joint committee, again, where appropriate. I'm therefore opposing opposition amendments 54, 55, 56, 57, 59. In subsection 2, the annual report will now be in such form and include information in respect of such matters as the authority considers appropriate. I've deleted the reference to, quote, or as the Minister may direct, unquote, in that subsection. I've also replaced quote, the authority giving to the Minister such other information as the Minister may require, with, and I quote, the authority now giving such information to the Oireachtas Joint Committee on Justice, Defence and Equality, or any Oireachtas Joint Committee that may replace that committee, unquote. I would hope the members would agree that these enhancements are desirable and acceptable and address any issues of concern.
Okay, thank you, Minister. Deputy McLaughlin, do you want to come back on that?
I think it's similar to the previous one where, in fairness, we've a meeting of minds. So, and in fairness, I do acknowledge the Minister has addressed a very significant concern of the independence of the authority in the previous amendments, and I think there's a consistency now in the amendments he's bringing in. So in that spirit, I will, when the question is put.
When the question is put. Deputy Collins, there are other amendments down in your name here. Do you want to comment on those?
Yeah, I just want to make the comment that I'm quite pleased that the Minister has moved from the position as originally published in the bill to where we're now arriving at in terms of positioning this committee. I think it's very good for democracy and for oversight. And if you look at for example, what's happening in Irish water, and I'm not transgressing. You know, it's just there was no opportunity for public representatives to play an oversight role. If you look at what happened in my native city of Limerick over the Christmas with the City of Culture, again, you didn't have the opportunity for public representatives to have oversight. So I'm just making the point, and I'm making the comparison, that we're moving to a situation where people who populate this committee, you know, ourselves and people who come after us, will have the opportunity to play an important role. That is very, very welcome. So,
point is well made.
Yeah.
Thank you, Deputy.
Thank you.
Deputy McGrath, do you want to come in?
Just on that, and I promise, Sir Chairman, I won't mention NAM and issues like that. But listen, just basically, I mean, importantly, I welcome the Minister's the position on the particular amendment, and also because the reality is that the independence of the authority and the accountability issue to the Oireachtas, that's a very, very important thing. Thank you.
Okay. Put the question. Sorry, Minister, do you want to come back in briefly?
It was always intended, and indeed the manner in which the legislation was framed, that the authority would operate as an independent authority. The bill was prepared in an extraordinarily speedy period of time. The deputies will recall the government was formed on the 9th of March 2011 under the agreement entered into by the previous government with the Troika. The legislation was supposed to be published by the end of September 2011, and when I came into government, no work had been done on it of any great significance. It was inevitable, because of the complexity of the issues that arose and the breadth of the issues that arose, that there would be a considerable amount of fine-tuning required following the consultative process on the bill. In different circumstances, it would have been preferable to have published, as the deputies are aware, I do with the majority of legislation from my department, it would have been preferable to be in a position where you could publish a draft bill for a public consultation process. But the time frame to meet the Troika's requirements rendered that completely impossible. So I'm just anxious to emphasise that it was never intended that this authority would operate in any manner other than independently. And I think these are important amendments, so that there's no perception otherwise. I know that Deputy Collins wants to make a bit of a splash on the water issue.
Let's not go there, Minister. Sorry.
We'll all stay away from that.
Minister,
Who's right to the Phoenix over the Christmas?
let's not.
You never told us about that.
Excuse me.
I was only joking.
Okay,
Deputy. Don't look so serious.
Let's move on. The question is that the new section be there. Be there instead. But Deputy Doctor, who stands that amendment? You said you.
Well, in the spirit of the Minister's address in the matter, I'll withdraw the.
You withdraw that amendment. Amendment number 54 withdrawn. Amendment number 55. In the name of Deputy Collins, I already discussed with 54. How stands that amendment?
Yeah,
You have to move?
I can withdraw that as well.
You're withdrawing. Okay. Amendment number 56 in the name of the Minister and Deputy McGrath. Now, 56 is agreed, 57 cannot be moved. This is already discussed with 54. Minister to move?
Move.
The question is the amendment made. Is that agreed? Agreed. Amendment number 57 cannot now be moved. Amendment number 58 in the name of the Minister. If 58 is agreed, 59 cannot be moved. This is already discussed with 54. Minister to move?
I move.
That amendment, question is the amendment made. Is that agreed? Agreed. Amendment number 59 cannot now be moved. The question is that section 17 is amended stand part of the bill. Is that agreed?
Agreed.
Agreed. Now we're now on to section 18. Amendment number 59A. Now this is in a first additional list of amendments, so it's on a white list you have there. This is the name of Deputy Collins and Deputy McLaughlin. Okay, acceptance of this amendment involves the deletion of section 18 of the bill. This is proposing a new section. Deputy Collins to move.
Just a second, Chair.
Is this one the Law Society, Chair?
I don't know. It's number 59A. Section 18.
Practice, yeah.
Deputy Collins.
Okay. I think there was the concern there was in relation to the to section 18. Sorry, just give me a minute.
Section 18, yeah.
Yeah. In relation to the codes of practice, that the Minister had himself very much up front and centre in relation to that, and I think, Minister, at a conference in 2012 you stated it was
Through
your
the chair,
intention.
please, Deputy. Through the chair.
Yeah, that the Minister stated it was his intention that professional bodies will continue to set their rules, regulations and practices and codes of conduct for their members. And we felt that Section 18 ran counter to that stated intention by the Minister. So we've, in consultation with both legal, with the Bar Council and the Law Society, we framed this amendment.
Okay. Right. Okay. So there's a doctor, sorry.
Yeah, this is a matter of concern for a number of important stakeholders out there. But again, Minister, I assume in the spirit of what you've done previous that you'll accept this amendment, and that what would not be acceptable is that the Minister would be perceived to be having control over codes of practice and matters like that. And the issue of the separation of powers comes to mind here. The ICCL have expressed concern around this, and I presume, Minister, just in the spirit of the amendments you've made to date, that you would accept the need to change this section to clearly reflect that it's the authority in consultation with the various representative groups of the legal fraternity that would agree on codes of practice rather than the Minister signing off on them.
Okay, Minister.
Well, firstly, I want to thank the deputies for tabling the amendment to give me an opportunity to discuss this issue. The adoption and taking on board of the deputies' amendment would affect the deletion of Section 18 as it now is. And I cannot agree to the deletion of Section 18 in relation to codes of practice and its substitution with the amendment that the deputies are proposing. But I'm certainly interested in revisiting this particular provision. I will be returning to this section at report stage with further enhancements following detailed consideration of the section by Advisory Council and the Office of the Attorney General. The reconfigured text of Section 18 had not been settled to the satisfaction of Parliamentary Council in time for us to deal with this when we tabled this group of amendments last July. And it was too late for me to table an amendment to it in the context of where we now stood. So there has been work done on this, but as previously stated, I'll be bringing forward a specific amendment in relation to this session, obviously to remove ministerial consents. There are issues around that, but there are also other matters that we're considering in relation to codes of practice. In the context of the Deputies' Amendment, it is, of course, inconceivable that codes of practice issued by an independent regulatory authority would be, in essence, subservient to the professional bodies whom it seeks to regulate. But obviously, there would be a consultative engagement that would be important in relation to codes of practice. So, again, this is a matter that I intend to come back to revisit. I'm not happy with the manner in which the amendment is framed that the deputies have submitted, and I'd invite the deputies, perhaps if they would do so, to not put their amendment today and to put it back to report stage, and we will bring forward an amendment or amendments at report stage, and we could revisit the matter at that time.
Okay.
Can I just ask through the chair, what particular aspect of this amendment as tabled can you flesh out your concerns, Minister, please?
Well, firstly, there are issues around this. I don't want to create any unnecessary disagreements. There are issues about the manner in which this is framed, if I can just put it that way, that we want to just give careful consideration to. There are, as I say, there has been work done on looking at this particular section, but Parliamentary Council isn't happy entirely with what's been submitted, and we have to ensure that whilst it's important there are engagements by the Legal Service Regulatory Authority with professional bodies and indeed with others that are appropriate and deemed appropriate by it with regard to codes of practice. It's important that we very carefully ensure that there aren't unnecessary constraints on the Legal Services Regulatory Authority. So I'm merely suggesting to the deputies that the matter is put back and we'll revisit it at report stage.
Okay. Deputy McLaughlin, yeah.
Chairman, I think this points up, because there's a little bit of a leap of faith in a lot of these matters, assurances. Can I just ask the Minister, can he assure us that ahead of the next, ahead of the report stage, that we will have his amendments in advance of our deadline to submit amendments? Because that way then we could look to see, obviously, if we're not, we won't know. We're going blind, so we will have to resubmit this amendment again for report stage. But if we had advance notice of the Minister's changes, and there's one from earlier and this one now, it would assist us in our own work. So, I mean, if the Minister's asking us, I can only speak for myself, the Minister's asking myself to consider, holding back on this amendment for now, in the clear understanding that it will be addressed, at a later stage, will the Minister give an assurance that we will get advance copy of the amendment before report stage, so we're not going through all this rigmarole again? That's all I ask.
Well, firstly, can I just say I appreciate the drafting that has been done on this amendment, because it quite clearly provides for a consultative process and ultimately facilitates the Legal Services Regulatory Authority making or prescribing a code of practice deemed appropriate based on the principles of the legislation. But there are some other issues that need to be considered in the context of this section. It was always my intention and hope, and I would have articulated this to deputies, that the various amendments that were published last week would have been made available immediately prior to the Christmas break to deputies. It proved impossible to achieve that because of the technical work that was being done and because of pressures on the Attorney's Office. So I do appreciate that the time frame that I envisaged back in early December for making amendments available today, and the ones we're discussing at the moment were tabled back in July last, wasn't fulfilled. I do think it's reasonable that amendments are furnished, giving deputies some reasonable time to furnish amendments to amendments if they wish to do so. So all I can say to the deputies, I would do my best to ensure in the context of report stage amendments that there's some adequate period of time for the deputies to consider those amendments to facilitate any work that needs to be done.
Okay, thank you. All right.
Chair, I'll just quit. Section 18. Are we still on Section 18?
We're actually dealing with the Amendment 59A.
All right, okay.
We'll be putting the section.
Yeah, I'll come back to you then.
You want to come back to that stage? All right then. Okay, now I just want to ask Deputy Collins, Deputy McLaughlin, Deputy Collins first, how stands that your amendment?
Well, I'll press the amendment, Chair.
You're pressing the amendment. Okay. On amendment number 59A, the question is that a new section be there inserted. Those in favour say Tá.
Tá.
Those against say Níl.
Neil?
I think the question is lost. Amendment 59A is lost. Now, I'm putting the section now. You want to come in the section, Deputy McGrath?
Yeah, we're talking about Section 18 here
Yeah.
now, Chair. Is that right? Yeah. Just a couple of broad general points. First of all, in relation to when we're dealing with the issues like legal services, and when you talk about codes of practice and you're talking about professionalism and issues like that, I think it's very important that when you're dealing with these issues and when you look at the kind of work that goes on in the legal profession, I think it's appropriate as well that we deal with the issue of the Law Society and their administration staff, because I think there is a highly group of skilled people out there who have a very highly skills, and I just think that there's no room for administration errors. So I'd just like to ask the Minister, does he have a concern in relation to the Law Society staff being made redundant, because I feel very strongly that you need people working in this area. We need the highest standards. I think it's very, very important that we highlight this issue as well.
Okay, you're stretching it, but I'll allow
I know,
that.
but I
Okay.
just think it's
Go
important
on.
that we say that.
Minister.
I don't think the deputy is talking about the codes of practice, but what he is raising is an issue that is a matter of some concern, and it relates to the staff within the Law Society who are currently dealing with issues of complaints and allegations of misconduct by solicitors and what their position will be. Of course, ultimately, the Legal Service Regulatory Authority will be the body dealing with allegations of misconduct, and also, as the deputies will note from the amendments that have been tabled, we're providing for a very extensive, or we're making extensive provision for what I would describe as consumer complaints being dealt with in a mediated fashion without the necessity of invoking the full disciplinary panoply of the legislation in circumstances where there aren't allegations of misconduct, but there's simply what could be properly described as a consumer complaint. We are giving thought, and we have been engaged in discussions with the Law Society about the position of their staff. I understand we're talking about approximately 16 members of staff who would now be affected by the changes. There are a number of issues, and I don't want to publicly go into all of these issues. It's certainly, and I'm genuinely interested in the views of other members of the committee on this, and I'd invite members of the committee to comment on this. It's very important this body, when established, is seen to be and operates as independent of the legal professions. The purpose of providing for a legal service regulatory authority was to ensure that disciplinary, amongst a variety of functions it has, is to ensure that disciplinary issues, allegations of misconduct made against members of the legal profession, are dealt with by a body which isn't connected directly to the professional bodies which represent either branch of the profession, and that it's a body that is clearly independent of the branches of the profession and is perceived to be independent by the public. The difficulty is with a lot of good work that has been done by both professional bodies, there are still public doubts about the independence of the process, and I'm very conscious that both bodies would assert that where there are allegations of misconduct, they do independently and properly investigate them. And I know, for example, the Law Society could quite properly point to cases taken by it which have resulted in members of the legal profession being struck off. But we're trying to establish and seeking to establish a body about which there can be no perception other than it's independent. One of my concerns in relation to there are two particular issues in relation to the staff within the Law Society. They clearly have substantial expertise in this area.
Minister, can I intercede there for a moment, please? We are deviating
Sure.
very much away.
Well, I'll complete this quite quickly, Chairman.
Please.
They clearly have substantial expertise, but should it be possible? Firstly, there will be individuals clearly to be recruited to this body. Should it be possible, for example, to put together a legal structure which would facilitate some of these individuals becoming members of this body or working for this body? There are a number of issues.
Sorry, Minister.
Would there be a suggestion that would undermine the independence of the body?
Minister, I really have to ask you to stop.
We'll come back to it on another.
Section 20. Yeah, so
We'll come back to
ask members if you would please. I'll try to be as helpful as I can to members and to keep it as open as possible. But we will be here all day and forever unless we focus on the amendments hand specifically. So please try not to deviate away from the actual amendment. And I'm sure all the other issues will be covered in time. So I want to just draw a line to that now. The question is. This is being the question. Where are we now?
We're on the section, Chair.
Section 18, yeah. New section, and the question is that section.
No, this is the existing
15.
Section.
Sorry, that section 18 stands part of the bill. Is that agreed?
Agreed.
Agreed. Okay. Section 19. Amendment number 60 in the name of the Minister. 60 and 61 are related and will be discussed together. Minister to move. Amendment 60.
I move, Chairman. The proposed government amendments that we're now discussing together are primarily aimed, like several other amendments tabled today, at simplifying the CEO provision while removing any ministerial role in relation to the specific matters concerned. The new provisions in relation to the process of appointment of the Chief Executive of the authority will, if accepted, be similar to that of the new Irish Human Rights and Equality Commission. Deputies will note that it is the Minister for Public Expenditure and Reform who will have a role in approving the terms, conditions and remuneration of the Chief Executive, which is in keeping with my desire to ensure that the costs of the new authority are kept within a reasonable and sustainable level for the legal practitioners who must fund it.
Okay. Deputy Collins.
Just through the chair, can I just clarify? You're not putting a time constraint on the term of office of the CEO. Is that correct?
I don't think the legislation has a time constraint, but that's an interesting issue. If the deputy has a view on that,
No, I'm just reading the bill here. Are you deleting? In the original bill, a person who has held office as chief executive shall be eligible for reappointment, but shall not hold office for a period the aggregate of which exceeds 10 years. That's been deleted. Is that correct, Chair?
Yes.
Yeah. So the CEO can hold office for more than 10 years.
Yes, it would be a matter ultimately for the Legal Services Regulatory Authority itself to determine what the period of office should be and whether, how to deal with that issue.
And
it's leaving it with the discretion.
Okay, and can I further ask, just in relation to the CEO, how will that position be? What's the word I'm looking for? Analogous to the civil and public service. At what level will it be? Assistant Secretary, Principal Officer, Secretary General? What grade are you looking at?
Well, that'll be a matter for
the authority as well?
For deeper in consultation, the authority in consultation with deeper. Now, it may well be I'll be able to provide the deputy with further clarification of that issue at report stage.
Okay, thanks. Anyone else? All right. I put the question then. Amendment number 60. Question is that the amendment be made. Is that agreed? Agreed. Amendment number 61. Minister to move.
I move.
This is already discussed with 60. The question is the amendment be made. Is that agreed? Agreed. Amendment number 62. 62, 63 and 73 are related and will be discussed together. Minister to move number 62.
I move, Chairman. Again, the proposed amendment to section 25, which is amendments number 62 and 63, and amendment number 73, are all part of the suite of amendments aimed at removing ministerial consents and to provide greater clarity with regard to the workings of the legislation.
Okay. Anybody on that? Okay. The question is on amendment number 62. The amendment made. Is that agreed? Agreed. Amendment number 63 already discussed with 62. Minister to move.
I move.
The question is that the amendment be made. Is that agreed? Agreed. Agreed?
Agreed.
Agreed. The question is that section 19 is amended stand part of the bill. Is that agreed?
Agreed.
Agreed. Section 20, amendment number 64 in the name of the Minister. Acceptance of this amendment involves the deletion of section 20 of the bill. And if 64 is agreed, 65 cannot be moved. This is a new section. 65 is an alternative to 64. 64 and 65 will be discussed together. Minister to move.
Chairman, the proposed Government Amendment 64 is a revision of section 20 of the bill and removes the Minister's role in relation to the appointment of staff to the authority while maintaining a role for the Minister for Public Expenditure and Reform in relation to the relevant conditions of employment and remuneration. This is consistent with the architecture that we were discussing earlier. It's only right, I believe, that the new regulatory authority will appoint its own staff as an independent entity and not have its HR resources determined or in any way fettered by a minister. This further enhances and protects the independence of the body on an ongoing basis while not compromising on the need to control regulatory costs. However, I will be in continued consultation with the Minister for Public Expenditure and Reform on the HR and other aspects of the establishment of the new authority. I think we're also taking opposition amendment 65. I'm opposed to this amendment as the authority is being established as an independent body. It's not within my remit as member of the government to predetermine its decisions in relation to the configuration and recruitment of staff in order to perform its statutory functions effectively. It will be open to the existing staff of the legal professional bodies as matters stand, who would obviously possess the relevant skills to apply for positions advertised by the Legal Services Regulatory Authority. But I want to come back to what was raised earlier. And of course, it would be open to the existing staff based on the bill as it is presently framed to apply for positions. But I was coming back to the issue of concerns in this area. Firstly, I recognise the substantial expertise within the Law Society amongst a group of individuals who have been dealing with complaints in relation to misconduct. And when these matters are ultimately taken over by the Legal Services Regulatory Authority, that they will cease to have a role ultimately in that context. It has been suggested that they should be transferred from the Law Society to the Legal Services Regulatory Authority. Well, firstly, there isn't in place provisions usually to facilitate the transfer of staff from a private body to a public body, and there are certain legal complications around that issue. And as I said, it is open to members of the Law Society who are working in these areas to apply to the Legal Services Regulatory Authority when they advertise their positions for positions on that authority, and quite clearly they would have an advantage in the context of the experience and expertise that they have. From a human perspective, I can appreciate that it would be very helpful to the individuals concerned, and from a practical perspective in the context of the body benefiting from their experience, that they be recruited to it without the matter being unduly complicated. But there is an issue surrounding this which I'm quite happy to publicly air, and which should be publicly aired. It isn't simply an issue about protecting the jobs of 16 individuals. There is the wider public issue about the independence of the authority. We've just gone through a whole range of amendments, to ensure there can be no perception of any ministerial control over the authority. The purpose of the legislation is to provide for an independent authority which is not merely independent of the minister of the day, but is independent of the professional bodies. Now, there are 2 or 3 issues here. If arrangements were to be put in place which facilitated by some legislative mechanism, if it were possible for me to obtain the agreement of Minister Howland's department, and I don't know is that possible, but if it were possible, and if such a legislative structure could be created, would it create a risk that the public would perceive that the body is less than independent because a portion of the existing staff have simply been transferred? Existing staff from the Law Society have simply been transferred to the body, as opposed to going through a recruitment process in respect of which many individuals may apply for jobs and they'd be independently and separately assessed and interviewed. Had I published, when the legislation was published, I would suggest to deputies, had I included a provision in it for the transfer of all the existing Law Society staff who deal with these issues to this body, I'd been open to the accusation that it isn't an independent body, that we're just recreating the Law Society disciplinary process under a different name. And Deputy McGrath may have been one of the first out of the hatches to suggest that, because people certainly didn't lose any time in suggesting that because we reflected the structure of other similar bodies in requiring ministerial consents in certain areas, that I was deliberately setting out to undermine the independence of the body. So I'm interested in deputies' views. The deputies present here today, would they be supportive of an arrangement which would facilitate such a staff transfer? Would they see it, or would they not see it, as undermining the independence of the authority? Would they be supportive? Would they regard it as within the objectives of the legislation to allow for such a transfer, or should members of the staff of the Law Society, and I don't like talking about individuals publicly, but there's no point in conceding the complexity of this, should those individuals simply be in the same position as others? If they wish to work for the authority, they apply for the positions that will be available. And So I'm very interested, Chairman, in members' views on this, looking at the complexities of it, as opposed to simply representing a concern which is perfectly legitimate, that has been expressed to me very forcibly and understandably by the Law Society on the part of their staff. But I have to ensure that I do nothing that undermines public perception that this is an independent body. And having said this, I am very happy to listen to what deputies have to say on this issue. This isn't something ultimately that I can resolve as Minister for Justice, because it does involve Minister Howland's department, and there are certain legal complexities around this that I don't want to publicly air that will be of relevance to the staff members individually, and to the Law Society, and to an authority. And there is, of course, the issue that you can't transfer staff from a private body to a public body without all of the staff within the private body, of course, wanting to be so transferred. And whether all of them would wish to be so transferred is a matter for their individual decision. So I'm conscious there are various issues around this. I'm very interested in Deputy's views.
Deputy McLaughlin, on amendment number 65, your amendment.
Thanks, Chairman. Chairman, as you know, one of the issues that has been debated is the perception in the public that the current system of the Law Society or the Bar Council, through their respective structures, investigating complaints, the perception was that it was them investigating themselves. Now, if you actually look in an honest way at both at the Law Society and Bar Council structures, they were very robust and very fair. And indeed, the Law Societies you had the option of an independent party to go to if you weren't happy with their decision. But there was a perception in the public eye, and the allegation was made many times that this is the legal fraternity investigating the legal fraternity, especially if you had an outcome that you weren't happy with. So that was the perception. But in Britain, the regulatory authority allows them to continue to investigate, so the various fraternities continue to have their own investigatory structures that are under the supervision of the authority, regulatory authority. So it isn't the regulatory authority directly carrying out these investigations. That's the system in Britain. However, the Law Society has accepted that there is a public perception and has supported clearly the concept now that you're putting forward of a independent regulatory authority. So there is clearly going to be a change. The reality is that the staff that are there right now, working there, these are very complex matters that require people of substantial expertise to look at. The staff there have many, many years of experience of dealing with these cases. That means that, and there is precedent here of changes happening, new structures being put in place where the existing staff, I suppose as a matter of natural justice, who work in that area, continue on to the new structure. And you take all of that expertise and you hit the ground running with the new structure. And I think it would be very helpful to have a new authority that is clearly independent, that is strengthened in all sorts of regards by this legislation. But to have a staff, a core element, that have the expertise, that have the knowledge, that understand the system, that means that authority starts in the best way possible. There are other matters too, that you will have a situation, if we allow this legislation to continue as it is, where you will be making all of those staff redundant, and then you have the hiring costs, the advertisement costs. So there is actually going to be a cost, not just to the Law Society, who will be making a substantial contribution to the new regulatory authority anyway, but you're also going to have a considerable cost to the public, to the taxpayer, of hiring and rehiring. I do hear the concerns the Minister has put out, and he has invited the opposition to express their view. I'm saying that I believe that the transfer of the staff who have worked and have that expertise, I'm saying in my view, would not undermine the independence of the new authority. And I think that you'd be bringing that level of expertise over. What I would ask the Minister to do, I don't assume that we'll resolve this today in this committee session, but I would ask the Minister to consider the points we made, to engage obviously with Minister Howland, to engage with the Law Society and other interested parties. There will be other bodies who may have an interest in this too, and to see what kind of solution can be found. Can I also say that we have representations from the trade unions in relation to this matter? The trade unions have expressed concern that we have essentially a new body that performs the same work that these, I think it's about 60 staff, currently perform, and that they would, you know, like I think it's important to say that there is no question mark that these 60 staff, there's no question mark about their independence, their professionalism, their fairness, the way that they carried out their work. I'm not aware that they've ever been castigated or found to have not carried out their work with professional and independent diligence. I appreciate there was a perception that it was a legal fraternity investigating the legal fraternity, but there's no question mark or never found to be any wrongdoing. So what would be happening in effect is we're creating a new, and it is an independent authority that the Law Society have supported and have chosen to support, but we'd be actually punishing the staff and creating all sorts of difficulties. So, Minister, I think a solution is here to be found. If everybody approaches it in the will, you've asked for the view and maybe the comfort of the opposition's perspective. I certainly won't attack you. I've obviously made my position clear today that I think there is a natural justice issue of transferring the staff over and putting in place whatever criteria, protections, whatever is needed. You may have, I appreciate you won't take 60 staff in the positions they're in right now and directly put them into new positions. You may want to put in place protections. I think there's a way of transferring these staff and taking advantage of their expertise while protecting the independence and the perception of independence in the new authority. And that's and it has happened. There is precedent in the past of this happening, and I would ask you to consider. You may not support the amendment that's here today. I think the amendment here today is a very safe amendment. It just merely says that they may. It just allows the authority to appoint. It doesn't say they will or shall. It just allows them to have that option. It's a safe enough amendment. But you know, I would just say, would you consider looking at this in advance of report stage and having an engagement with the various interested parties to see is there some solution that can address all of our concerns?
Okay. Deputy Powell, did you want to come in on the same issue?
Yes, thank you, Chairman. I just wanted to address it. To be fair, an awful lot of what I was going to say has been covered by Deputy McLaughlin with regard to the staff. I mean, I don't think there's any question that these particular individuals are competent, experienced and professional individuals who perhaps are exactly what the new authority are going to require in terms of their own experience. I accept what the Minister is saying in terms of the need for independence, but I suppose you've alluded to it yourself by referring to Minister Howland and discussions with this committee and the discussions with himself with regard to an exception being made on this occasion. But taking on board your point about independence, the requirement for independence or the perception of independence, and the requirement for the prerequisite experience, I would imagine that any individual applying for a role in the new regulatory authority is going to go through some form of public service appointments type interview process, and obviously that those skills and experiences gained while working for the Law Society are going to be of great benefit to those applicants. But I suppose, going back to the crux of the matter, that doesn't necessarily give any comfort to those 16 individuals. So, you know, I think it's something that maybe should be teased out with further discussions, particularly with Minister Howland. But I do think that in any normal scenario, when we're looking at the establishment of a new authority and bringing in competent individuals, I would have to assume that these individuals will be the type that we will be looking for. So I understand the Minister's predicament, but I suppose further discussions are required. But I would certainly be in favour of a reasonable approach to this being taken with regard to the future employment of these individuals.
Deputy Collins.
Thanks, Chairman. The Minister has asked for our views, and I would concur with the Deputy McLaughlin and Deputy Farrell. I think we need to have a sense of proportion in relation to it. We're talking about 16 individuals. You know, it's not a huge. We're not getting into hundreds and into thousands. What we're effectively looking for is a transfer of undertakings in relation to this staff. Am I right in relation to 16? 16.
No, I think it's what it is, to be accurate about it. I think there are approximately 20 individuals affected, but some work part-time, so it's the equivalent of 16.
16
It's the equivalent of 16 full-time. That's my understanding of it.
So, you know, in terms of a sense of proportion, that's what it is. And the points have been very well made in terms of expertise and working knowledge. And if you look at, for example, the establishment of CAB or the establishment of GSOC, you put into place people who had knowledge and skill in those particular areas of work in those particular organisations. And I think you need to do the same here. And Deputy McLaughlin made the point very well, hit the ground running. That's the important thing. These people know, they know the legal services providers right around the country, and I think there has to be a mechanism found to accommodate these, otherwise you're left with duplication. Thank you. Deputy McGrath.
Yeah, I want to strongly support Amendment 65. And I'm glad to say as well, I'm delighted to see that the Minister seems to have gone all very ethical on the issue of the independence of the authority and worried about undermining the independence of the authority. Can I say, Minister, you said there are complications. Chair. Can I say that the Minister is concerned about the complications? I think some of us are going to be running on the plinth denouncing him over the next couple of weeks over this particular amendment. But can I say that we all had representations from the Law Society and we all had representations from Mandate, the trade union. That's their democratic right to lobby us as members of the Oireachtas to protect their jobs and terms and conditions, and good luck to them. And I'll stand up for them today and make no apologies for it. But in relation to the independence issue, I think it's very important that the Minister doesn't get carried away with this issue. And I've heard it from my colleagues here. There will be standards, there will be procedures when you're applying for these positions. But I definitely think that these experienced staff who have great skills that mightn't necessarily be out there in the broader society and other people applying for the positions. And I think they're a highly skilled group of people, and I think they should be transferred to the particular authority. To use an example as well, maybe, just in case the Minister is kind of still feeling very, very ethical and really worried about undermining the independence of the authority. For example, if you can use in other scenarios, in my previous job, I was a primary school teacher, and a lot of teachers become inspectors in the Department of Education and Science, and they go around assessing primary school teachers and secondary school teachers. Some of them even go on to be members of the Teaching Council, which deals with these kind of issues as well. So I'm making the point is there are examples of where this happens, but it's time for the Minister to get ready. This is about administration staff. This is about people, highly skilled people. And if you're talking about 16 positions, I would be strongly supporting their transfer to the authority, and not to be made redundant, that they will be given the option to fill these positions. And also say to the Minister that he doesn't have to worry. I won't be pirouetting around the plinth in the next couple of days over this particular issue.
The mind boggles.
Thank you, Oireachtas. And through the chair, can I take up the Minister's offer to listen to the views of the members of the committee on this question of the staff? I'm sure, like other deputies, I've had a constituent who came to me expressing concern about her future employment with the transfer of from the Law Society, and I think she has legitimate concerns in that regard, and also the other deputies have raised this as well, and we've all got a letter from the Mandate Trade Union as well. I think everything should be done to ensure that people who are competent and qualified and are doing the job at the moment, and who have maybe long experience in that field, should be allowed to transfer or go through interview, whatever process is necessary to ensure that their employment continues.
Yeah, thank you, Deputy. Just on this, Minister, you did mention earlier on that there was, how can the Chair speak through the Chair? I don't know. Anyway, you did mention earlier on that this was different because it was public and private. But what's happening here, it seems to me, is that because we're setting up a public entity, we're actually, in effect, closing down a private entity. So there is that precedence, I suppose, going on as well, which you might take into account. Minister, do you want to respond to the deputies?
I do. there is some.
It's a transfer of employment undertakings, isn't it? Legislation.
There is some precedent. Much of it, though, is in the public-to-public area. But firstly, I want to thank deputies for their considered comments. I hope Deputy McGrath will forgive me to say that I know he rarely misses the opportunity for a pirouette on the plinth. So I appreciate his
Minister Rabbit.
I appreciate him not pirouetting on this issue. Look, this is a serious issue for the individuals concerned. We can't deal with it simply on the basis of because representations have been made, we have to make X decision. But we have to make a decision that's in the public interest, whilst also being conscious of the position of these individuals. Now, I certainly recognise that they are people who have expertise that would be of value to this body when established. I don't know personally whether all 20 individuals who make up the 16 full equivalent, would wish to be employed by this body. And I'm sure that's something readily ascertainable. We have been engaged with discussions with the Law Society and, of course, received their submissions on the issue. The amendment tabled by Deputy McLaughlin, which was a useful focal point for discussing this issue, wouldn't actually achieve what his objective is. I think his objective is that individuals be transferred effectively to the body. His amendment says that the Minister may permit the authority to appoint members of the Law Society and Bar Council's administrative staff with the requisite qualifications and whose positions will be displaced with the commencement of the authority. Well, there's nothing preventing the authority at the moment recruiting or employing a member of the Law Society who does this work. And that, come back to where I started on this, that would facilitate or ensure that there was no barrier to a member, for example, an individual working in the Law Society in this area at the moment, applying for a job. And there would be no barrier to them being given the job based on what the deputies proposed. But what the deputies proposed doesn't achieve what the deputy, I think, is talking about, which is providing for positions, if we assume all 20 would like these positions, for all 20 of these individuals within this body. It's just saying there's no barrier to them being recruited. It's not actually providing for their recruitment. So it doesn't actually achieve that objective. This is an issue of complexity, because from a human position, we don't like to see individuals who do their job carefully retaining their employment. And from a human position, we don't want to achieve that. There are complexities in this. The complexities are, of course, we're still in the area of public service constraints, the context of new bodies coming into being, and we're trying to reduce the number of bodies we have. This has been necessary to create a new body here. One of the means of staffing is transfers from other parts of the public service, where there are individuals with the relevant expertise who can be so transferred, and that ensures it keeps expenditure down, which is important. But quite clearly, this body will have to recruit some individuals of experience and expertise we don't have within the public service, individuals who have worked in this particular area to any significant degree. So this is an important issue. But I want to thank deputies for allowing me now to be able to go back to government and to say that there is support across all sides represented in the House for what is being proposed in this context. It doesn't mean necessarily, I'm afraid, that I'll get sanctioned for this, but it's certainly something I'll further enter into discussions with the Law Society in relation to. There are issues deputies haven't adverted to of importance, and they would be of importance to the individuals concerned. There are, for example, issues relating to their pension positions. I don't have the detail of what their pension positions are with regard to their current employments, but quite clearly if they're parties to private pension schemes couldn't be continued when in the public service. So that's an issue that of complexity. There are issues around the redundancy legislation in the context of what's being proposed. And certainly individuals employed currently by the Law Society it's not like the takeover of a private company by another company. They couldn't be compelled, for example, to work for the Legal Services Regulatory Authority if they didn't wish to do so. And in circumstances in which their employment was terminated, they would have certain redundancy entitlements. So there's a lot of complexity around this. It's not as simple as even Minister Howden, if in principle this was feasible, simply making a decision and it being affected, because it brings into play pension issues, redundancy legislation, the rights of each of the individuals concerned. But I certainly want to say, Chairman, I think this has been a very helpful discussion in our continuing to see how we address this issue, and I want to genuinely thank members for the discussion and for what they said. I would invite, I know I seem to do this with some regularity, but I would invite Deputy McLaughlin not to put his amendment, because it doesn't actually achieve the objective he set out to achieve, but it has achieved the objective of facilitating an important discussion around this issue. And I will report back to the House on this at report stage. I can't make a commitment on this. I can't make a commitment that the Legal Service Regulatory Authority will be taking all of these individuals into it if they all wish to be taken into it. I can't make that commitment. The commitment I can make is that I will further engage with the Law Society and with the Department of Public Service and Reform in relation to the issues and some of the complex matters that we haven't discussed that I've mentioned.
Okay. Sorry, can I come back in?
Of course, yeah.
Yeah, just to say, I appreciate your commitment to engage with the Law Society and Minister Howland's Department, Public Expenditure Reform, in relation to this. Minister, you would know this better than most, that in terms of the issues that the staff will be dealing with in the new authority, and there's no doubt about their independence, because I think the legislation, when it's finalised, will enshrine that independence clearly in the public eye. But they will be complex matters, and they will require people of considerable expertise from the get-go. And there is a request yet to be acceded to, that on the day that the new regulatory authority commences, that it would take all cases ongoing and new, that would be a fresh start, not two parallel processes running at the one time. So there is the hope, and I share that hope, that we will have a fresh start, new regulatory authority, all cases going under its umbrella. And the concern would be that there would be a temptation, as you alluded to yourself, to transfer staff, civil servants, from the public sector over to that. But frankly, with all due respects, there may be some, but it would be very hard to get the range of staff that are required. So it may solve a kind of a numbers exercise within overall public service. It may be tempting for Minister Howland to do that, but it wouldn't be a good outcome for the public. And in terms of resolving the matters. And also, we want this regulatory authority to be a fresh start. We want it to win the hearts and minds of the public from the get-go. We want it to have all the capacity and capability. And I think, Minister, you know yourself that the staff that are already working in that field would make a huge contribution to making that happen, rather than people who have been transferred for a numbers exercise from other government departments. So anyway, I just want to wrap up by saying I do appreciate your commitment. I accept the amendment I have. It's not a world-class amendment. It doesn't achieve what I want, but I wanted to have a discussion about it today. There is another amendment that's been ruled out of order.
That's all you can't.
No, so I'm just alluding to the fact it's been ruled out of order, nothing more than that. but I think it was important to have a discussion today. Okay. If you're making a commitment, I know you can't give an assurance that it will be resolved today, accept that, but if you're making a commitment that you will engage with the parties and try to find a solution to this, then I will withdraw when it's put to me. Okay.
Okay. Deputy Collins, you want to come in as well? Briefly.
Can I just ask, Minister, in your consideration of what you've heard, which I think we're all on the same page here, will you will you undertake to sit down with the mandate trade union as representatives of the 16 people involved? And bearing in mind my comment earlier on in relation to proportionality of all of this, not all 20 of the 16 post holders may wish to, some may wish to retire or do whatever, we don't know. But will you undertake to sit down with the mandate trade union?
Deputy Minister, I was actually going to come in on that issue because I noticed the Minister in his remarks, he talked about the Law Society and he talked about the Minister, but he didn't mention in his response earlier on about mandate. So I just would encourage him to do that because we want sensible options for these administration staff.
Okay, Minister.
Well, could I just come back to, well, I want to correct one thing. When I said I was referring to staff members, that there may of course be someone employed in this area within the Bar Council side of things who would be in a similar position. I don't want to exclude them from the discussion that we're having. This has been an important discussion. I want to say it's been quite clear from an early stage that the Law Society had a concern about their staff, and when the Law Society, certainly by the time the Law Society had expressed support for the new independent system that was being put in place to deal with disciplinary matters, they would have raised that issue well before I think the trade union raised the issue. I'm not going to get into trade union negotiations on this matter. There are technical legal issues that arise that are of some remain of concern, and there's certain practical matters that would need to be addressed with Minister Hallin's department. But I don't think there's an issue surrounding there isn't an issue, frankly, that would require an engagement with mandate. There's an issue that does require each individual being clear as to what they would like to do if it proves possible that we can develop this. I want to keep on emphasising, as I don't want to be accused of misleading anyone, the if it proves possible, because there are difficulties in this area, and I don't want to suggest that there are difficulties that will be made by my ministerial colleague. I don't know to what extent issues relating to pensions and redundancy rights and legislation have been factored into the considerations here. That's something that we will discuss directly with the Law Society, and if the Bar has a similar issue, we'll discuss with them. On the issue that Deputy McLaughlin raised, yes, this is about trying to provide a new start and to ensure that there's no perception on the public's part that when allegations of misconduct are made, they're investigated by anything other than an independent body. And in an ideal world, a seamless transition whereby even outstanding issues in being were taken over by this body has a lot to commend it. And again, that's a matter that consideration is being given to. There are very substantial legal issues around that, very substantial, which careful consideration has to be given. You couldn't have a situation where there is a serious allegation made against a member of the legal profession that has detrimentally impacted, whose alleged conduct has detrimentally impacted on a member of the public or members of the public, where that matter was in the course of being addressed within the current structure that exists, and legislation was enacted which ultimately had an effect whereby the current structure was instantly dismantled and there was a legal barrier to the matter being progressed by the new structure. Now, I'm not going to go into the technical legal issues here, but I do think there's a difficulty in the transitional proposal that has been made to me being implemented in the context of the legal rights of individuals and the constitutional rights of individuals who are in the course of having an issue, for example, adjudicated upon within the existing structure. And these are issues we're going to have to be very, very careful in dealing with. And they are matters that we are further looking at very, very carefully, so that there aren't unintended consequences contrary to the public interest affected by our seeking to provide for that type of transitional measure.
Okay, I think we're satisfied. We've had a good discussion on this.
Yeah, Minister, again, I put this to you again. Is it possible for you to make available to us before report stage the amendments so that we can have a chat? You know, obviously I am going to withdraw this amendment when it's put to me. I'm preempting, but what I say about this, and this is a bit of good faith I'm asking for. I reserve the right to obviously put in a stronger amendment at report stage, but I would hope that I would have something on this and other matters from yourself to assist in that process before report stage. This isn't your typical, bill that we deal with that we just put in amendments and work away. This is heavy stuff that we could do with having advance notice of, so we can, to help us in the drafting process ahead of report stage. I don't have a full department at my disposal.
Okay. I'm just anxious to move on now.
I'll be very brief. If I could say to the Deputy, most of the legislation we seem to deal with, or I seem to deal with, could be properly described as heavy stuff in the sense of the volume of it and
heavy stuff then.
and the importance of it in different areas. The only assurance I can give the Deputy is I don't think it's satisfactory that report stage amendments be published at the very last minute within the time frame, the final day allowed by the House of the Oireachtas. I would certainly hope that before we take report stage, whatever amendments there are will be published at least an additional week over and above that, so that people have time to consider them, and I'll try and ensure that that does happen.
Okay. All right. If everyone is satisfied, I'll move on with this. Just to remind members and the Minister that Amendment 64, acceptance of this amendment involves the deletion of Section 20 of the bill. And if we agree the amendment, it means that 65 cannot be moved at all anyway, so it doesn't arise as it happens. But just to remind members as well that any issue that's raised here, whether it's by way of an amendment or just discussed, that it's perfectly in order to raise that at report stage as well, once it's raised here. So the question now is that the new section be there inserted. Is that agreed?
Agreed.
Agreed. The next amendment is out of order, and 65 cannot be moved. And the question now is that Section 20, we're on the section, that Section 20 is stand part of the bill. Is that? Now, I'm told the decision has to be no from the Minister, because we're getting rid of actually Section 20. We've already agreed to insert a new Section 20.
Right.
We're getting rid of the old Section 20.
So no.
No. Okay. The question is lost. All right. Okay then. Section 21, Amendment number 66, in the name of the Minister, already discussed with 41. The Minister to move.
I move.
The question is the amendment made. Is that agreed?
Agreed.
Section 67, in the name of the Minister, already discussed with 41. Minister to move.
I move.
The question is the amendment made. Is that agreed?
Agreed.
Amendment 68, in the name of the Minister, already discussed with 41. Minister to move.
I move.
The question is the amendment made. Is that agreed?
Agreed.
Amendment 69, in the name of the Minister, already discussed with 41. Minister to move.
I move.
Question is amendment made. Is that agreed?
Agreed.
That Section 21 is amended, stand part of the bill. Agreed?
Agreed.
Agreed. Section 22, Amendment number 70, in the name of the Minister. 70, 71, 72 and 75 are related and will be discussed together. Minister, move 70.
I so move, Chairman. The proposed amendments 70, 71 and 72 are minor technical amendments to correct typographical errors in the published bill, while Amendment 75 is, I'm advised, by Parliament, recommended by Parliamentary Council as a technical necessity for the drafting clarity of that particular section.
Everyone satisfied with those? Okay. Put the question then on Amendment 70, that the amendment be made. Agreed?
Agreed.
Agreed. Amendment 71, already discussed with 70. Minister to move.
I move.
Question is the amendment be made. Is that agreed?
Agreed.
Agreed. That Section 22 is amended, set part of the bill. Agreed?
Agreed.
Agreed. Section 23, Amendment 71A, in the names of Deputy Collins and Deputy McLaughlin. 71A and 71B are related and will be discussed together. This is on the white list, I think, is it? Yeah. Deputy Collins to move. 71A. white list.
I move, Chair.
Okay.
Just move, yeah.
You just move the amendment.
Yeah.
Deputy McLaughlin,
I'm
want
going
to
to
comment on
speak. Yeah, I'm going to speak to this amendment.
Yeah.
The reason why this amendment's in is that if you see 24(3), it requires that the chief executive shall not be required to give account for the committee for any matter. So it's in relation to. We would have concerns about just the implications of it, basically.
Right, Minister, do you want to?
Yeah, can I say to the deputy, in the context of this particular section, it's very much along the lines of it's part of the architecture of similar bodies, and that's why it's there. But of course, this body is being dealt with differently in the context of its independence. On a personal level, I don't personally see why the chief executive of this body, if he or she has some critical opinion to express about the merits of some government policy, I don't personally see why they shouldn't be free to express them. It doesn't, to me, make a whole heap of sense, and indeed, in the context of reasserting the independence of the body, I can not see a merit in necessarily retaining the section. Can I say to the deputy, could I ask the deputy, for the simple reason that his amendment was a last-minute amendment, and as a procedure I would normally go through in advising colleagues of amendments that I'm accepting and where we're going, could I ask the deputy to hold this, both deputies, to hold this amendment to report stage in the context of saying to you, I, on a personal level, think that it's an appropriate amendment to make, but I would like to do it in a manner where I at least inform colleagues that we're intending to travel this route. The technical answer is that the attorney would like a little bit more time to consider it, I suspect, but I don't see the purpose of this provision at this stage in this bill. I think it replicates provisions put in place where you have state bodies that are reporting to ministers as opposed to state bodies that are clearly independent of ministers.
Yeah, the Minister's very kind. I was obviously reading from the wrong subsection earlier. Yeah, it's an important matter, and I appreciate the Minister's response to it in that, and I'll read it. In giving evidence to the committee under this section, the Chief Executive shall not question or express an opinion on the merits of any policy of the Government or a Minister of the Government, or on the merits of the objectives of such policy. And then in 24(2, in giving evidence to the committee, the Chief Executive shall not question, and again it's the same point again. And obviously a General Secretary, when he comes before, or
yes,
she comes before a committee, is a government department. They're not going to question government policy, but this would undermine the independence of the authority. It's an important amendment, and I appreciate the Minister acknowledges that. Is the Minister saying that he will support such an amendment at report stage?
I'm saying
let's be clear on that.
If the deputies would temporarily withhold it to report stage, I think I can say to the deputy, unless I'm otherwise persuaded, it's highly unlikely that I'll do anything other than accept it.
Okay. All right then. Amendment number 71A. Deputy Collins and Deputy Silas, you withdrawn. Right, withdrawn and withdrawn. Amendment withdrawn. Amendment number 7. Section 23 stand part of it. Agreed. Section 23 agreed. Someone say agreed. Agreed. Section 24, amendment number 71B, already discussed in 71A. How stands the amendment?
Yeah, withdraw.
That's withdrawn. Deputy McLaughlin?
Yeah.
Withdrawn. Amendment number 72 in the name of the Minister, already discussed with number 70. Minister to move.
I move.
The question is the amendment, is it agreed?
Agreed.
Agreed. The question is on the section. Section 24 is amendment stand part of the bill. Agreed?
Agreed.
Section 25, amendment number 73 in the name of the Minister, already discussed with number 62. Minister to move.
I move.
The question is the amendment, is it agreed?
Agreed.
Number 73A is out of order. The question is that section 25 is amended stand part of the bill. Agreed?
Agreed.
Section 26, that section 26 stand part of the bill. Agreed?
Agreed.
Agreed. Section 37, amendment number 74 on the Minister is because of 41. The question, Minister to move.
I move.
Question is amendment made. Is that agreed?
Agreed.
Agreed. Section 27 is amended. St. Patrick's Bill. Agreed.
Agreed.
Section 28. The Section 28 St. Patrick's Bill. Agreed.
Agreed.
Section 29. This section is opposed by Deputy McLaughlin, Collins and McGrath. Deputy McLaughlin to move, I think.
Okay.
Discuss it.
Yeah, again, Minister, this is the issue of the independence of the authority, and so it's around the references to the Minister, and again, what we there's no amendments, but what we want to say is, presuming that my other two colleagues, is that, and another one will come in a while, is that we would like to see anything that suggests that the authority is, accountable to the Minister. That we want to demonstrate clearly in all texts, in all sections throughout the bill, that it is an independent authority. And I say, in the spirit of what you have done to date, I would ask that you would consider for report stage. We can't resolve it today, but you would consider for report stage addressing these issues.
Collins?
Yeah. It would just make sense, I suppose, if we withdrew the amendments, but will the Minister, can he give us the undertaking that he can bring forward amending wording at report stage to address the
Well, could I just point out to the deputies, this isn't an issue about independence at all. Subsection 5 of section 29, which the deputies are proposing be deleted, provides that following well, in fact, let me go to subsection 4. It says, as soon as practical after receiving a report under this section, the Minister shall cause a copy of the report to be laid before each House of the Oireachtas. And then, following compliance with subsection 4, the authority shall arrange for the publication of the report in such form and manner as it considers appropriate and for consent of the Law Society. What this isn't about the Minister interfering in anything. What this is doing is ensuring that important information is made available. Important information which may impact on public policies. And effectively, Section 29 provides for an annual report on admission policies of the legal professions to be prepared by the authority and submitted to the Minister. The Minister has no role in interfering with the report. The Minister's only role is to, in a formal way, place it before both Houses, and that's the mechanism for a report to be placed before both Houses, for both members of the Dáil and the Seanad to access it. I can't agree to the deletion of the section as is proposed. It's important for the provision of regulation of legal services in the state that the authority knows exactly the number of solicitors and barristers admitted to practice each year. It's also important for the authority to assess the demand for the services of practising barristers and solicitors, and the need to ensure an adequate standard of education for persons admitted to practice, and to ensure that the number of persons admitted to practice as solicitors and barristers in that year is consistent with the public interest in ensuring the availability of such services at a reasonable cost. It's reasonable that a report of this nature be furnished to the Minister. I see no reason why it shouldn't be furnished to the Minister. It's reasonable that it be lodged before both Houses, so that all members, not just members of the Joint Oireachtas Justice Committee, for example, can access the report. So frankly, Chairman, I don't see anything offensive about the section. It's a practical provision which ensures that certain information is annually collated, is made available, that the Minister who's ultimately responsible for legislation relating to the legal profession, the Minister who, for example, has brought in this legislation, my successor at some stage in the future may want to amend it, or if I'm around long enough, I may want to amend it if some issues aren't working. It's purely to ensure that important information is made available to the Minister, made available to members of the Oireachtas, and frankly, I don't see a problem with this particular section.
Thanks. Yeah, I accept that that's the deletion of the section wouldn't be the way to deal with our concerns. I suppose if you look at the first, it's 29.1, shall prepare and submit to the Minister a report. I suppose the way to deal with our concerns would be to change to the Minister to directly to the Houses of the Oireachtas. So again, there's no perception that the authority is under the control or remit of the Minister. And in previous amendments earlier on have have sought to do that. And again, it's removing any perception anywhere through the bill that the authority is not independent. So I accept the points that the section being deleted would not be desirable, but a change from the Minister to the committee, the relevant committee, Houses of the Oireachtas, would be the objective.
I think, Chairman, we've had a very interesting discussion on staffing issues. I think it would require extraordinary intellectual gymnastics to suggest that this section, as it is, could be remotely perceived by anybody as undermining the independence of this body, and I simply won't accept that the proposal be deleted, which is the only matter before the committee.
I put the question that the section 29 stand part of the bill. Is that agreed? Agreed. Section 30, amendment number 75 in the
The record that's withdrawn by both. That 29 is withdrawn. We didn't confirm it, whether it is withdrawn.
Right, okay.
In good faith, that the Minister might address our concerns later on.
Right, okay.
I'm not addressing any concerns.
Section 30, amendment 75 in the name of the Minister. Already discussed with 70. The question is amendment made. Is that agreed? Agreed. Now, I put the section, this section is amended to part of the bill. I know that this section is opposed by Deputy McLaughlin, Collins and McGrath, section 30. The question is that...
It's the same issue again. It's the same issue as previously outlined. So, again, if the Minister was to look at this issue, I think he can accept the point that's been made. We're not, it's not about deleting the sections. It's just making sure there's consistency in independence of authority throughout the bill. Simple as that.
Because I've given various assurances as we're going through this bill. I'm giving no assurance about this. I want to be very clear about this. There's a general obligation on the part of the Minister for Justice of the day to ensure matters are being, certain information is available and can be considered in the public interest with regard to any policy that the government may wish to follow or any legislative changes they wish to implement. And what this does is provide that certain reports and information be made available to the Minister of the day, and they all deal with matters of public policy issues, and they're public policy issues to be properly considered by government, and I'm opposed to any change to section 30.
Yes, this is a compromise, Minister, that you would look at to the Minister and to the Houses of the Oireachtas. You could say it's pedantic, but it may be a compromise.
Well, any report that is made should of course be published, and subsection 7 of section 30 provides the Minister shall cause copies of any report referred to in this section to be laid before each House of the Oireachtas within 30 days of having received it. Well, so quite clearly any report that's published, that's furnished to the Minister as prescribed in section 30 will be laid before both Houses.
Yeah, but there's no harm in saying it in the first instance, that it's the Minister and to the Houses of the Oireachtas.
That's not before us at the moment. So.
No, I'm just trying to, this is an engagement.
Yeah, I'm satisfied, Chairman, that this section will fulfil its objectives.
I put the question then that section 30 is amended stand part of the bill. Is that agreed?
No, I press that.
Okay. The question is that section 30 stand part of the bill. Those in favour say Paul.
Paul.
Those against say Neil.
Neil.
I think the question is carried. Okay. Section 31. The section 31 stand part of the bill. Agreed?
Agreed.
Section 32. That section 32 stand part of the bill. Agreed?
Agreed.
Now, section 33, amendment number 76 in the name of the Minister. Amendment of this, acceptance of this amendment involved the deletion of section 33 of the bill. If 76 is agreed, 78 to 80 inclusive cannot be moved. Now, 76 is an alternative to 77 to 80 inclusive. 77 to 82 inclusive are related. 78 is an alternative to 77. 80 is an alternative to 79. 82 is an alternative to 81. 76 to 82 inclusive will be discussed together. And it's about inserting a new section. Minister to move and debate.
I so move, Chair. The Government's amendments number 76 and 82 proposed to part 3 of the bill consist of the deletion of all 9 sections of the part as published, and the assertion of one new section dealing with the authorisation of certain legal practitioners to hold clients' monies. The new part entitled Holding of Clients' Monies by Legal Practitioners will therefore contain only one only one section. That section, section 33, provides that only solicitor legal practitioners may hold the monies of clients. This obviously reflects and does not alter the current situation whereby solicitors and not barristers may hold clients' funds. It's important to note that the part is linked to Part 7, which will also fall to be considered at committee stage, and which will provide for a public consultation on whether or not the restrictions on barristers holding the monies of clients should be retained, and whether or not the restriction on a barrister receiving instructions in a contentious matter as defined by the bill directly from a person who is not a solicitor should be retained. The new Part 3, with its sole section, has been designed to facilitate amending legislation if it is decided through the future consultation process that barristers ought to be permitted to hold clients' monies and to deal directly with clients on a broader range of matters than they are currently allowed to. The deletion of Part 3 as it stands in the published bill is a reflection of the policy decision that the Law Society will retain its regulatory remit in relation to the oversight of solicitors' accounts as they pertain to the Solicitors' Compensation Fund. The basis of the decision was my belief that the Society is best placed to incentivise compliance by solicitors because it is the solicitor's profession itself which is liable for claims on the fund. Before an annually renewable practice certificate can be issued to a solicitor, the solicitor in question must have paid an annual contribution to the compensation fund, currently set at around €760 per solicitor per annum. I'm told that the net assets of the Solicitors' Compensation Fund were valued at around 18 million euros in 2013. Around 400 accounts inspections were carried out by the Law Society last year, providing an important protection against acts of fraud and dishonesty by solicitors in the handling of clients' monies. The fund has been relied upon in a number of high-profile cases in recent times. Since 2008, the fund has paid out nearly 20 million euros in claims. However, I wish to make it clear that the disciplinary procedures in relation to acts of fraud and dishonesty or the misappropriation of funds will be conducted by the new and independent professional conduct regime in the bill. The provisions which I propose to be deleted are ones that mirror certain provisions already found in the Solicitors Acts 1954 to 2013. They should remain untouched in the Solicitors Acts in relation to the Law Society. Under Part 4 of the Solicitors Amendment Act of 1994, the Society is responsible for the protection of clients, which includes an obligation on the Society to maintain and administer the Solicitors' Compensation Fund. Where it is proved to the satisfaction of the Law Society that any client of a solicitor has sustained loss in direct consequence of fraud or dishonesty on the part of that solicitor or their clerk or servant, then subject to the relevant provisions, the Society is required to make a grant to that client out of the fund, and so the position will remain. It is not desirable in any circumstances that the state should assume responsibility or potential future liability for a breach of financial regulations by practising solicitors. This would involve the state assuming a very substantial burden which would, in the process, lessen the very serious incentive for compliance that currently exists. I should point out that under the compensation fund structures provided for under the Solicitors Acts and to be maintained under the bill, the Law Society is able to respond immediately to serious financial complaints and has the right to carry out investigations without notification where justified by the circumstances. The Law Society is also under the Criminal Justice, Money Laundering and Terrorist Financing Act 2010 required to investigate compliance with anti-laundering regulations. As I have said, any matters of professional misconduct or discipline that may arise from cases of solicitors' fraud or dishonesty will be dealt with independently by the authority or the legal practitioner's disciplinary tribunal, as the case may be. In relation to opposition amendments number 77 to 82 inclusive, tabled by Deputies McLaughlin and Collins to sections 33 and 34, they seek to restrict the application of Part 3 to solicitors only, presumably because they have been persuaded by the arguments of the Bar Council that barristers should in no circumstances ever be permitted to hold the monies of clients. As I have already stated in relation to Amendment number 76, I intend to indeed continue with the restriction on barristers holding clients' funds, at least until the outcome of the relevant consultation process in which the new legal services regulatory authority is to engage is known. Therefore, I propose instead to delete sections 33 and 34, insert the revised section 33 that I've tabled.
Okay. Right, Deputy Doctor.
Yeah. In relation to our amendments, I think you've addressed them anyway with your own amendments, so that's fair enough. But what I do want to raise now under Part 3 is the substantive issue of the compensation fund. This is an area of understandable concern for the Law Society, and they've made a detailed submission to yourself and indeed to ourselves as committee members on this. And I think it's a reasonable point that they're making. I mean, the Minister has stated that the state and the taxpayer would not want to take on the financial burden of compensating clients for the dishonesty of all, if it and it has materialised where there is a requirement for a compensation fund. What's happening here is the legal fraternity have put together through a levy and indeed insured a fund that would protect the small number of citizens or clients who have been victims of criminal or corrupt or behaviour, and that's a good thing, and we need that to continue. But the issue that the Law Society raise is that they need to have teeth. So you have a compensation fund, it is backed up by insurers, but the insurers need to see that the Law Society can actually move quickly and enforce the disciplinary issues that arise. And also sometimes you may have to take a High Court injunction or try to freeze money, try to have control. So in other words, you've set up a compensation fund, you've levied solicitors, you have insurance interest in that. You need to be able to demonstrate to keep that at an affordable level for solicitors, that you need to be able to demonstrate clearly that you have the enforcement capacity. Now, in fairness, from reading the Law Society's submission in relation to this, they're not arguing that they retain full enforcement. They're arguing for some type of a cooperation with the new regulatory authority. But I'm sure you can appreciate, Minister, the dilemma here is that it's sort of fragmented what's being proposed. On one hand, the financial fiscal responsibility for the dishonesty of some individual solicitors still rests with the Law Society, but they haven't any role in the enforcement, and indeed it's quite a cumbersome process what's been outlined right now. So what I'd be asking you to do, and I don't have any amendments, but I do reserve the right, Minister, to bring forward amendments at report stage, that you would engage with the Law Society, and I'm not sure if this applies to the Bar Council also, but you would engage with the Law Society to try to address the concerns. I think they're very legitimate concerns that they've raised. It is in the public interest that a compensation fund be retained, and it's also in the public interest that the independent regulatory authority cooperates and oversees the process. So I'm hoping that some halfway house can be found to address the understandable concerns that have been outlined to us.
Okay, Deputy Collins, do you want to come in on that
Yeah,
as well?
thanks, Chair. Just through the Chair, Minister, if I could ask if you could engage with the Law Society in relation to this particular matter, because it's something which is particularly critical to the proper functioning of the new authority in conjunction with the Law Society. And can I ask, through the Chair, Minister, just your rationale? Can you give us, articulate to us your rationale for seeking to permit barristers or members of the Bar Council to handle and retain and hold client monies?
Okay, Minister.
All right, let's deal with a number of issues first. This bill, as the deputies will recall, when published, made provision, as of course was necessary and appropriate in the public interest, that the Law Society will continue to administer the compensation fund. The legislation in place in relation to that was largely unaffected. And it envisaged that the inspectorate currently attached to the Law Society that conducts the type of inspections that I detailed earlier would in fact transfer to the Legal Services Regulatory Authority, so that we have the Financial Inspectorate would be attached to the Legal Services Regulatory Authority, as well as the function of investigating allegations of misconduct. And there was a very substantial case made that the Compensation Fund and the Inspectorate shouldn't be separated, in the sense that the Inspectorate has substantial experience in inspecting the accounts of solicitors, that as solicitors fund the compensation fund, and annually the amount they have to pay into it may be determined by the liquidity of that fund. It creates a pressure on the Law Society, who I'm not suggesting wouldn't otherwise do the job, but it does create a pressure because they have to, and the Council of the Law Society have to be concerned about the position of their members, to ensure that the Inspectorate fully fulfills their functions. And it was argued that the Inspectorate should remain with the Law Society, and we gave further consideration to legal issues in that context. And I had a concern that, in fact, if the Inspectorate came within the Legal Services Regulatory Authority, it could create a situation whereby, even where the Inspectorate performed to the nth degree and engaged in their job with absolute professionalism, that any time there was a loss of monies by a client because the solicitor defrauded them, that there would be an incentive on the part of somebody within the legal profession to recommend to their client they now sue the state. So as well as looking for compensation from the compensation fund, the state could become a mark. And it was important that didn't happen. So the amendments that we've tabled today are designed to enable the Law Society, as indeed the Society itself sought, to retain the Inspectorate. But I made that decision not because I was lobbied on the issue. I made that decision because, on reflection with regard to the legal difficulties that could arise in the context of the Inspectorate being part of a state body, I considered it was advisable that, in fact, the Law Society, on reflection, retain that function, and that where there's allegations of fraud, the Inspectorate be asked to investigate accounts, and that the Law Society continue to perform the very important function they perform, which is to do a spot check audits on a specific number of solicitors' firms on an annualised basis in circumstances where there are no allegations of fraud or misconduct, but to ensure that the appropriate accounting rules are being complied with, that client accounts and office accounts are being appropriately maintained, that clients' monies aren't being improperly used, and that there isn't insofar as it can be ever policed, a repetition of the type of instances that we have seen, which have resulted in prosecutions being successfully taken against some solicitors. So, as a consequence of the changes, the Law Society will retain the Inspectorate. I expect that function will be fully fulfilled by the Law Society in accordance with their statutory obligations, and that the Inspectorate will do their work in a manner that's appropriate to try and protect, in the public interest, clients of the legal profession, to ensure that solicitors' accounts regulations are fully complied with, and to ensure that compensation isn't unnecessarily having to be paid because the Inspectorate functions in a manner that's negligent. And I'm not suggesting that they are doing so. I don't want to be misinterpreted. I'm just saying I could see there's a synergy between the Law Society maintaining the compensation fund and retaining the Inspectorate function. But that's where it stops. And what's interesting now in the context of some of the material that's been made available to me is what I would describe as mission creep. We're going from a position where there's a very good case for the Inspectorate to being retained, to special pleading that some of the disciplinary functions should now be retained also by the Law Society, and I fundamentally disagree with that, and I want to be clear on that. We are going to have, under this legislation, in the public interest, an independent disciplinary and regulatory regime. That effectively means where there is misconduct alleged or discovered with regard to the manner in which a member of the legal profession, be they a solicitor or a barrister, conduct themselves, that misconduct issue will be addressed through the appropriate structures of the Legal Services Regulatory Authority. To come back to Deputy McLaughlin's case, so there's no public perception. So there's no public perception of any description that the body dealing with this is anything other than independent. Now, the case that has been made is, what happens if something comes to the notice of the Law Society's inspectorate that requires immediate intervention, that requires an emergency court case, for example, to freeze solicitors' accounts in some shape or form? Well, what would happen now, as I understand it, is that the information that comes to the Law Society would result in an application being made to the courts, I'm presuming, except in very, very exceptional circumstances, on foot of an affidavit that's sworn detailing the circumstances why a court order should be made. Where you have an independent regulatory regime or structure under the new Legal Service Regulatory Authority, with statutory provisions that the Law Society retain the inspectorate function, there's absolutely no reason why a mechanism couldn't be in place which ensures that where there's a need for an emergency court application to be made, it's made by the Legal Services Regulatory Authority on foot of the information that the Law Society furnishes. And that doesn't mean that it's furnished and it takes people weeks to deliberate on what's been furnished where there's an emergency. The same judgments can be made as are currently made, and it ensures that the disciplinary function and the regulatory function is separated from the inspectorate function. And if, in the context of that issue, there's any further amendments required to be made to the bill at report stage that can be made, there's no particular reason why there couldn't be, for example, a memorandum of understanding put in place between the Legal Service Regulatory Authority and the Law Society with regard to ensuring the speed with which these matters are addressed. So there's various ways in dealing with this, but it would be completely inappropriate based on, and I very much welcomed the support the Law Society has given for our having an independent disciplinary structure dealing with allegations of misconduct. It wouldn't be appropriate that we have some issues of that nature now retained by the Law Society, and then other pieces of it being dealt with by the Legal Service Regulatory Authority. It's not beyond human initiative to ensure that these matters can be dealt with seamlessly and efficiently by absolute cooperation where it's necessary between the inspectorate, who identifies something to be concerned about, immediately communicating that, an immediate response and appropriate, if need be, court application made. So I very much appreciate that what the Deputy has raised is on foot of submissions that he's received in this issue. It's an issue that has only arisen because of the changes that we're making to the legislation. I'm, of course, open to ensuring that anything additional that needs to be inserted in the bill as it's going through both houses is inserted to ensure that such matters can be dealt with seamlessly and in a manner that's in the public interest. But what I don't want to do is create now a separate piece of regulatory or disciplinary process which is similarly retained by the Law Society, not for any reason other than I think we should have a readily identifiable and simple structure. The inspectorate undertakes a particular function, the regulatory authority undertakes the other functions, and I think that's entirely workable.
Deputy McLaughlin, you want to come back on this briefly?
Yeah, from listening to your thoughts on this. I think that there is a possible solution to be found, and I would ask you to. You're going to engage the Law Society around the issue of staffing. That when you do that, that this is an issue you also consider with them. I hear your fundamental objections to the suggestion that they would continue to have the powers of discipline and enforcement, but I get a sense from reading their presentation. I'm just glancing over it here again, and what you've said, that there may well be some way of addressing the core issue, which is that the insurers can be assured that this fund is protected, and the cumbersome or concerns about duplication or concerns around bureaucracy might slow down a swift response to a crisis that would have an impact on the fund. That if there's a way found to demonstrate clearly to the insurers that no, this is a very fluid, fast-moving, cooperative process, that would be helpful. So I would just say, Minister, obviously there's no amendments to debate here, but just if you would deal with that when you meet the Law Society. I really, from reading their presentation, there's a genuine concern. It's, the fund is in the public interest. Everybody wants to protect it and make sure that it works effectively. So I think there's room for manoeuvre and negotiation to make this stronger and better. That's all I would say.
I appreciate what the Deputy says. I've absolutely no difficulty, and we would have already communicated to the Law Society. We're quite happy on this and a number of issues to engage with them from the public interest perspective. And of course it's in the public interest that nothing be done to undermine a capacity for a swift response should something untoward be identified that requires a swift response to protect the public, to protect a client or clients of the legal profession, and of course to ensure that monies aren't misappropriated. And I'm very happy that we work through that. It's an issue that arises out of the changes that we're now implementing, and I've no doubt that should there be any need for any further amendments to the bill in this context, we'll come to them in report stage.
Okay. Everyone happy? Yeah, go on. Deputy Collins.
Could the Minister, through the Chair, address just the query he had in relation to the intention that was in the bill to allow members of the Bar Council to hold client monies?
Well, what's in the bill, as the Deputy will recall, is that the Legal Services Regulatory Authority engage in a process and report on whether the public should have direct access to members of the Bar for contentious matters, and for matters which may, in those circumstances, if you have direct access to members of the Bar for contentious matters, it means you won't be filtering your legal problems through solicitors. And that's a matter of interesting discussion. I don't want to prejudge the consultative process and that will take place in which the Legal Service Regulatory Authority will engage, and the report in which it will publish. I know that within the legal profession that's a matter of some controversy. The legal profession in Ireland exists as it does because we inherited the historical developments of the legal profession in Britain from between the 17th to the 19th century. And it has remained unchanged since then. The legal profession has practiced in other jurisdictions, including some common law jurisdictions, is structured differently to the manner in which it's structured in this country. And that issue will only arise should, as a result of the consultative process, there be, when a report is published, should it then be considered by government, and should government make further changes for further reforms. So it's premature at the moment to deal with that issue. Yes. And I've no doubt, like many other reforms that are under discussion, when it comes to both the professions, they're a matter of difficulty and controversy. People have concerns about change. I think it's an issue to be addressed, frankly, substantially, looking at what is in the public interest, what gives people access to appropriate legal assistance when they require it in a manner that doesn't generate unnecessarily excessive legal costs. I think that they're very important principles. What gives access to lawyers with the necessary expertise to address particular issues. There are areas of very complex law where certainly I would have no doubt that in certain circumstances where people find themselves in litigation, they do need the assistance of more than one lawyer, be they solicitors or barristers or both. I have no doubt about that. There are other circumstances where people have legal problems of a relatively straightforward nature, where if a lawyer has particular expertise, you don't necessarily need more than the one lawyer. But these are all interesting issues to be teased out in the public interest. I'm not going to prejudge them. The issue of whether barristers should hold funds or not is directly related to direct access to barristers for contentious matters by members of the public without barristers being instructed through solicitors. Normally it's the solicitors who hold funds, which is why there's very detailed rules and regulations and provisions in place concerning both what are known as client and office account in the context of funds received by solicitors and the holding of monies on deposits by solicitors. Very substantial rules in that area. At the moment, monies that barristers receive are by and large substantially paid by them through solicitors as opposed to barristers direct, except in some very, very narrow circumstances. So that's an issue that may be an issue for another day, well after the legislation is enacted and after many of the reforms prescribed by it have been brought into operation.
Okay, everyone happy so far? Nobody else? All right, then I'll put the question so then that the section 76, and the acceptance of this involves the deletion of section 53 of the bill. So we're talking about a new section with there inserted. Is that agreed?
Agreed.
Agreed. 77 cannot be moved, 78 cannot be moved, 79 cannot be moved, 80 cannot be moved, 81. Sorry, that's section 33. Sorry, as amended. Sorry, that's section 33 is part of the bill. Is that agreed? No, this should be in the negative. We'll say no.
These are sections we're deleting, I think.
That's section 33 is part of the bill.
Neil.
Neil. Is that agreed? Agreed. This question is last. Right. Section 34. Now, already discussed, this Amendment 81. If 81 is agreed, 82 cannot be moved. This is already discussed with 76. In the name of Deputy Collins, it's Amendment 81. How stands the amendment?
I'll press the amendment, please.
Sorry? You got to move it?
Move and press, yeah.
You're pressing it, okay. Let's get this here now, and we're on amendment number 81. The question has been made. Those in favour say "ta." Those against say "nee." I think the question is lost. Amendment lost. Amendment number 82 already discussed with 76. Deputy Doctor to move.
I move.
The question is that the amendment has been made. Is that agreed? Amendment number 82. Agreed. Yes.
No.
No.
Deputy
Same as the
Doctor is
previous one.
for, and I'm Neil.
Yeah, that's right. I think that the question is lost. Amendment lost. Now, what are we doing here? Yeah. Yeah, that section 34 stands part of the bill, and I think the Minister proposed that this be deleted, so
That's a Neil.
that's Neil. So that is, question is lost. Right. Section 35, Amendment number 83,
That's also
in the name of Deputy Collins and Deputy McLaughlin. Deputy Collins to move.
I move, Chair.
Okay. Anybody want to discuss the amendment?
Yeah, just to say, it's along the similar lines that we've got a series of amendments, myself and Deputy Collins, seeking to retain the current situation whereby monies are paid to solicitors and not to barristers. So I move.
Okay.
Well, on that, could I come back and say to the Deputy, based on where we are now, that actually is the way that the world stands. And for reasons already discussed in relation to section 33, I have to oppose those amendments tabled by the deputies and push for the deletion of these sections on behalf of the government in the reconfigured part 3 of the bill, as already explained.
Okay. What are we doing here? Right, how stand the amendment now?
I press.
Pressing the amendment, okay. Yeah. On amendment number 83, The question has been made. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I think the question is lost. Amendment lost. Now, section proposed to be deleted. Yeah, the question is that section 35 stand part of the bill.
Neil.
Neil. Section is lost. Section 36. Again, the same thing again here now. The question is that the section should stand part of the bill.
Neil.
And Minister says Neil. Okay. And the question is lost. Section 37. The section 37 stand part of the bill. And again,
Neil.
Neil. It's lost. Section 38. We're talking about amendment number 84 in the name of Collins McLaughlin. 84 and 85 are related and will be discussed together. Deputy Collins to move.
I move, Chair.
And you want to discuss those?
I just move it, Chair.
Just move it. Yeah. Doctor.
Yeah, the concern here is linked to a debate we're going to have later on, not today, in relation to the proposal around multidisciplinary practices. And the feeling is that these subsections facilitate what would be coming down the line in relation to accountants and being related. That's the interpretation. So out of concern, that's why they're in.
Okay. Minister.
Yeah, for reasons already discussed in relation to section 33, I must oppose these amendments tabled by the deputies, and again push for deletion of the sections in the reconfigured part 3 of the bill.
Okay. The question is then that how stands the amendment, Deputy Collins? Is that amendment 84? Deputy McLaughlin?
Well, I pressed.
You're pressing the amendment. Okay. Then the question is that the amendment 84 be made. Those in favour say Tá. Tá. Those against say Neil.
Neil.
I think the question is lost. Amendment 85, or discussed 84. How stands that amendment?
Press.
Pressing it. The question is the amendment 84. The question is the amendment made. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I think it's lost. And then on the section, that section 34 stand part of the bill. Oh, sorry, 38 stand part of the bill.
Neil.
Neil. Okay. It's lost. Section 39. The question here is that section 39 stand part of the bill. And the Minister
Neil.
proposed to be deleted. Okay. Section 40, the Minister's section proposed to be deleted.
Neil again.
That's Neil again. Section 40, that's Neil. Section 41, that section proposed to be deleted. Section 41 stand part of the bill.
Neil.
That's Neil again. Section 42. Amendment number 86 in the name of the Minister. 86 to 88 inclusive are related and will be discussed together. Minister to move.
Yes, Chairman. Firstly, I move. Part 4, as it stands in the published bill, consists of only 3 sections. The government amendments proposed, being amendments number 86 and 87, are very minor amendments to remove a ministerial consent to the making of regulations by the authority. I have already made it clear that I wish to remove from the bill as many references to the Minister as possible to ensure that the new bodies created by the bill are as independent from government interference or any perception of government interference as is possible. As regards Deputy Collins' amendment number 88, I am grateful to him for tabling it, as it was always my intention and my officials' intention to substitute the reference to Minister here with reference to the authority, as can clearly be seen with my deletion of very many other references to the Minister throughout the bill thus far, including indeed today's amendment number 87 to the same section. It appears to have slipped through the net, so I happily support Deputy Collins' amendment. It's my intention that the authority will continue to set minimum levels of insurance required by legal practitioners so as to ensure that any liability incurred is fully covered in the public interest, while the Law Society will continue to administer the relevant insurance schemes.
Okay. Anybody want to comment on any of those? Okay. The question then is on amendment number 86 that the amendment be made. Is that agreed?
Agreed.
On the section 42, the question is that the section 42 is amended stand part of the bill. Is that agreed?
Agreed.
Section 43. Amendment number 87 in the name of the Minister, already discussed with 86. Minister to move.
I move.
The question is that the amendment be made. Is that agreed?
Agreed.
Agreed. Amendment number 88 in the name of Deputy Collins, already
Agreed.
discussed with 86. Deputy Collins to move.
I move.
The question is that the amendment be made. Is that agreed?
Agreed.
Agreed. That section 43 is amended stand part of the bill. Is that agreed?
Chairman, can I come
On the section, of course.
On the section,
Yeah.
yeah. Section, Minister, again, there's an issue here around the professional indemnity insurance, and apparently you had recommended that the Law Society and others would retain control over this, and this is an issue that can impact on the obviously the level of insurance and the affordability. Not every solicitor is making a fortune out there. Many are struggling in the economy that we're in. So there is a real issue. And again, as you've undertaken to engage in relation to the previous matters, is this something that ahead of report stage that you could factor in? Yeah, and I see you have received a submission in relation to this that I've looked through, and I think that the concerns that the Law Society have made are valid, and it's worth looking at. So if you could consider this as part of your deliberations with the Law Society ahead of report stage, I would ask. And I say that I do reserve the right to make amendments at report stage if not.
Can I just say to the Deputy, there's no issue with regard to the Law Society retaining certain functions here, we've no difficulty discussing the matter with the Law Society. There are public interest issues which we're very aware of, and this particular section doesn't give rise to any difficulty in the context of what the objectives are.
You will discuss the matter?
We've no difficulty.
Yeah, that's good.
At
Okay.
all, yeah.
Thanks, appreciate that.
Okay, that's section 43 then is amended and part of the bill. Is that agreed? Agreed. Section 44, amendment number 89 in the name of the Minister, 89 and 90 are dated and will be discussed together. Minister to move.
Yes, Chairman, I move. These government amendments, again, are very minor technical amendments to address a text alignment issue.
Oh. Okay. Everyone happy with that? Okay then.
We will all be suitably realigned when.
Charming. The question is that the amendment be made. Is that agreed? Agreed. Amendment number 19, the name of the Minister, discussed 89. The question is made. Is that agreed? Agreed. That section 40 is amended to stand part of the bill. 44, sorry, is amended to stand part of the bill. Agreed? Agreed. Section 45, amendment number 91 in the name of the Minister. This proposes a new section. 91 to 97 inclusive are related and will be discussed together. Minister to move.
I move, Chairman. There are a number of important and significant amendments that we're now discussing. Government Amendment number 91. Now, in the context of this, we've created a new Part 5 of the bill. So just let me have some water as we're progressing along. We've created a new Part 5 of the bill to deal with the informal resolution of complaints relating to inadequate legal services and charging of excessive fees, but not grossly excessive. The Law Society, the lay members of the Complaints Committee of the Law Society and other commentators have pointed up the need to provide a framework for dealing with these type of complaints, which in essence would not amount to misconduct. The published bill was silent on how the authority would deal with the substantial number of complaints which tend not to amount to misconduct. The amended bill now provides a detailed informal resolution process for complaints relating to inadequate legal services and the charging of excessive fees. The charging of grossly excessive fees will now come within the definition of misconduct under a separate provision, however. Therefore, under this part, section 47, a client of a legal practitioner may make a complaint where the client considers that A, the legal services provided to him or her are or were of inadequate standard, or B, the bill of costs issued by the legal practitioner was excessive. Section 45 of our amendments provides that a legal practitioner will be considered to have provided inadequate legal services where, by act or omission, the legal services actually provided were not of a standard that is reasonable to expect of a legal practitioner as a solicitor or as a barrister. Government Amendment number 92, the admissibility of complaints, which is section 46, mirrors provisions which were previously contained in the bill as published. A complaint under this part will not be considered by the authority if, in the opinion of the authority, it is deemed to be A, frivolous or vexatious, or B, is without substance or foundation, or does not satisfy the other criteria set out in the section. Where the authority determines that it will not consider a complaint, the authority, where appropriate, will have to notify the complainant in writing, setting out the reasons. They will also have to notify the legal practitioner if appropriate. Government Amendment number 93 under the proposed new section 47, a client of a legal practitioner may now make a complaint where the client considers that A, the legal services provided to him or her are or were of inadequate standard, or B, the bill of costs issued by the legal practitioner is excessive. Government Amendment number 94, the new section 48, provides that the authority will carry out a preliminary review with regard to a complaint of inadequate legal services or excessive fees. The preliminary review allows the authority to determine whether the complaint should be dealt with under these structures for less serious complaints, or should be dealt with under the formal misconduct provisions. In making that assessment, the authority shall have regard to the extent that the standard of the legal services provided to the client fell short of the standard reasonably expected of a legal practitioner in the provision of those services. Section 48(2) provides that where, having completed the preliminary review process, the authority considers the complaints to be admissible and appropriate, it will notify the legal practitioner concerned, setting out the alleged complaint and requesting him or her to respond within the time period specified in the notification. Section 48(3) provides that the authority, following receipt of the reply, may admit the complaint and enter into further consideration of the complaint under this part, or determine that the complaint is unfounded, or request further information regarding the matter of the complaint. If the authority, having concluded the preliminary review and having considered any further response it has received, is of the opinion that the complaint, if it were substantiated, could constitute misconduct, it is open to it to decide that the complaint should be dealt with under the more formal misconduct provisions, and will so inform the complainant. That's under section 48, subsection 4. Government Amendment number 95. Under this amendment, the authority can facilitate resolution of complaints relating to inadequate services, section 49. If the authority is of the opinion that the complaint is capable of resolution, the authority may invite the client and the legal practitioner concerned to make efforts to resolve it. The authority under section 49(2) itself may facilitate the resolution of the matters which are the subject of the complaint in an informal manner, A, by offering its assistance to resolve the matter, or B, by identifying other persons to the legal practitioner and the client who are willing to assist in resolving the matter. This facilitation of resolution may include the referral of the dispute to mediation or other appropriate form of dispute resolution. Having allowed the client and the legal practitioner a reasonable period of time to resolve the matter, if the authority considers that an agreement or resolution between the parties is unlikely, it may give notice in writing to the client and legal practitioner that it proposes to conclude the dispute resolution process. The authority cannot conclude the dispute resolution process earlier than 30 days after the giving of notice under section 49, subsection 4, and on concluding the dispute resolution process, it is obliged to invite the client and the legal practitioner to furnish it with a statement. That's under section 49, subsection 5. The authority, under section 49, subsection 6, then considers the statements, and where it considers that the legal services provided by the practitioner have fallen short of the standard reasonably expected of a legal practitioner, it may direct the legal practitioner to do one or more of the following. And I'll go down each of these one by one. Secure the rectification at his or her own expense, at the legal practitioner's own expense, or at the expense of his or her firm, of any error, omission, or other deficiency arising in connection with the legal services concerned. Take at his or her own expense, or at the expense of his or her firm, such other action as authority may specify. Transfer any documents relating to the subject matter of the complaint to another legal practitioner or firm nominated by the client, subject to such terms and conditions as the authority may consider appropriate, having regard to the existence of any right to possession or retention of any of the documents concerned vested in the legal practitioner. Pay to the client a sum not exceeding €3,000 as compensation for any financial or other loss suffered by the client in consequence of the legal services provided by the legal practitioner, having fallen short of the standard reasonably expected of a legal practitioner in the provision of those services. Now, Government Amendment number 96, under this amendment, which is section 50, it will be possible for the client or the practitioner concerned to seek a review of the authority's directions or the authority's failure to make a direction. This will be done by a review committee of 3 persons, 2 of whom will be laypersons, and the third will be a legal practitioner. An application for the review of the authority's direction must be made in writing not more than 30 days after the authority has notified the parties to the complaint of its decision, and furnish a statement as to why the decision of the authority was either incorrect or unjust. The review committee will be able to confirm the decision of the authority, make a finding that the complaint is not well founded, or issue one or more of the directions to the practitioner which the authority is authorised to issue under section 49(6). They're the different directions that I listed a moment ago. Government Amendment number 97. In this distinct new section 51, the authority will be enabled to facilitate resolution of those complaints relating to excessive costs, where the main substance of the complaint is that the amount or any part of the amount of costs claimed by a practitioner in a bill of costs is excessive in a material respect, and the authority is of the opinion that the subject matter of the complaint is capable of being resolved. The authority may invite the complainant and the practitioner concerned to make efforts to resolve the matter that has been complained about. The authority may offer assistance in resolving the matter or identify other persons willing to assist in resolving the matter. It's a similar approach to the one previously mentioned. The amended section 51(3) provides the period beginning on the making of a complaint to the authority and ending 2 months after the complaint is determined can be disregarded in relation to the making of an application for adjudication of a bill of costs under Part 9. It will still be open to a client or legal practitioner to submit a bill of costs to the legal costs adjudicator if they cannot resolve under this informal resolution process. However, where a dispute regarding a bill of costs is resolved between the client and the legal practitioner under this section pursuant to this process, the client will not be entitled to seek the adjudication of the bill of costs under Part 9 unless such adjudication forms part of the resolution. In other words, what we are doing here is providing for a procedure to facilitate an amicable agreement being reached or an agreement being reached with the assistance, for example, of a mediator to resolve a cost-disputed issue without having to go through the full costs adjudication process before the legal costs adjudicator, but not creating any barrier to someone deciding to go through the legal costs adjudicator if they wish to do so. And of course, it would be possible where there's an attempt at an informal resolution that people would simply agree to disagree and agree that the legal costs adjudicator deal with the matter anyway. So this is just an extra provision to try and facilitate the speedy resolution of issues where there's a complaint about costs, but not costs that are grossly excessive. Under section 51(5), the authority will also be able to conclude on notice to the parties the dispute resolution process if it considers that an agreement or resolution of the complaint is unlikely to be reached. This is in the context of a cost complaint. I suppose, Chairman, what's worth adding in the context of this, the objective here is to ensure that what are consumer complaints, as opposed to complaints of misconduct, what are complaints about overcharging but not of a major nature, can be resolved in a speedier way. And in some of the work we've done on the bill, for example, there's a very successful complaints process of this nature being used in New South Wales at the moment in the context, and we've had an engagement with the individual who is in charge of the legal services regulatory functions in New South Wales, who introduced this informal complaint system, or what I should correctly describe as the consumer complaint system, not the informal complaint system. And it's had two effects. It's produced in New South Wales a far speedier and less bureaucratic structure for dealing with consumer complaints than previously existed. And I'm also told, because of the existence of this now for some years in New South Wales, has resulted in solicitors being more efficient in their dealings with clients, and that rather than it was expected that over a number of years the number of such complaints would actually increase, but having in the early years increased, they're now decreasing. apparently, because of the approach that's been taken in dealing with complaints, has now stimulated on occasions where there's disagreements between the solicitor and the client, they're resolved without the need to use even this type of process. But it's envisaged to ensure that it's the serious complaints made will be dealt with in the regulatory structure. Consumer complaints have the possibility of being dealt with otherwise, but in dealing with cost issues, the availability of the legal cost adjudicator in relation to any issue in dispute in relation to costs is not in any way impeded. And there's no access barricade created. There'll be full access, but this will readily provide a mechanism to facilitate a resolution where it is possible without the need for an individual to resort to legal cost adjudication unless they choose to do so.
Okay. Right, anybody want to come in on that? Deputy
Yeah, just make the comment that any informal process which will help the consumer to arrive at a speedy outcome, which is acceptable, obviously, is welcome.
Okay. Deputy McLaughlin, yeah.
Yeah, one of the submissions we've received, all the committee members, is a proposal or suggestion that there should be a 5-year time limit on the ability to make complaints. I think that's reasonable. That's if somebody has an issue around costs and and so on, that really you should be making that fairly. Sorry, Minister, did you say 3 years?
Yeah, no, well, firstly, I think there is a need for a time limit. The bill already prescribes a 3-year time limit for making application to the legal cost adjudicator, having paid a bill. There's a 3-year time limit within which you can make a complaint thereafter. And I think it's important we have consistency in the bill, in the legislation. I think 3 years after someone has discovered there's a reason to complain is, I think, sufficient time, to possibly rather than 5 years, to allow for the making of complaints. We also, though, have to be careful. There are circumstances that can arise quite clearly where someone may not know that their legal issues haven't been dealt with appropriately. Let's take, for example, I go to a solicitor and I buy a house and I pay for the house and I'm paying my mortgage on the house, and 15 years later I decide I want to sell it, and I discover, unknown to me, the solicitor has the house registered in his or her own name. Now, that's not very far away from certain difficulties we've recently seen. You couldn't have a situation where someone couldn't 15 years later, upon discovering that, make a complaint. So I think we're looking at how we frame this. On the cost complaint issue is very straightforward. In other complaints, there's just a need to go with care on this. But I don't think it is right that you have an open-ended, that like 50 years or 30 years, as could happen at the moment in theory, after someone has completed legal work for someone, they make a complaint. That isn't reasonable either. But I am aware of members of the legal profession who 20 or 30 years after they completed work for individuals have had complaints made against them that have proved to be spurious, but the Law Society would have been in a position where they still had to deal with it in good faith and process it. So we need to provide the appropriate balance to ensure that if someone has no reason to know their affairs haven't been dealt with appropriately, when they discover they've been dealt with or believe they've been dealt with inappropriately, they can make a complaint, but that there is some time frame that's prescribed. So we're going to come back to that at report stage.
Sorry, just to continue. Minister, in relation to the mediation bill that's coming later this year, I see, am I right to understand that you're trying to incorporate what's coming down the line into this? Like, is there flexibility in this, in these sections to, to anticipate, what the new processes that will come under in the mediation bill? And just to say, I think the mediation bill, in terms of cost issues and resolving matters, could be as important for the citizens out there as this bill. So much of what happens in family law and civil law could be resolved in an early stage with a robust mediation process. So I just wanted to establish, and we've had a bit of a dialogue in the chamber about this. So where's your thoughts on it?
Just to come back to the previous issue, just on the issues of admissible complaints, 3 years is prescribed in Section 2, subsection 1 for admissible complaints, and it addresses the issues that some of the issues we were discussing earlier, but we're just going to have a look at one or two other bits of this that we need to ensure are in sync. Look, the bill on mediation is really complementary to what we're doing here. What quite clearly we're doing here is, in certain circumstances, the Legal Service Regulatory Authority, where there's a consumer complaint that the parties themselves aren't able to resolve through perhaps the offices of the Legal Service Regulatory Authority itself, it creates the possibility the Legal Service Regulatory Authority may propose that the parties would go to mediation rather than turning the thing into something that is more long drawn out and possibly more expensive than may be necessary. But what we're not doing is we're clearly not going to put in the bill in this bill provisions that will be contained in the mediation bill to deal with access to mediation issues and some of the principles of mediation that we're working on. So I see the mediation bill as complementary, not just here to this, but it's complementary, frankly, to every circumstance in which an individual may be contemplating court proceedings. But there is a complementary nature between, in connectivity, I should say, between.
Okay. Deputy Collins, you want to come in as well?
Just in determining the admissibility of complaints post a 3-year period, who will set down the criterion, or will they all be looked on a case-by-case basis? Will somebody develop a criteria for admission of complaints outside of 3 years? You've instanced an example. I'm sure there's an endless scenarios that we could come up with.
They would primarily be considered by the Complaints Committee in the context of the individual issues that arise. The 3-year thing, though, coming back to this, because Section 2, subsection 1 on admissible complaints is important, doesn't prescribe a limit where the complaint relates to fraud or dishonesty by a legal practitioner, and that's the example I gave, but there just may be some, as I say, tweaking we need to do. But primarily it would be an issue for the committee to make that decision. But we are giving further consideration to that as we head into report stage.
Okay, everyone satisfied? Well then, we'll put the questions. So, on amendment number 91, in the name of the Minister, Minister to move.
I move.
Question is that the new section be there and inserted. Is that agreed?
Agreed.
Agreed. Amendment number 92 in the name of the Minister, already discussed with 91. Minister to move.
I move.
That the question is that the new section be there and inserted. Is that agreed?
Agreed.
Amendment number 93 in the name of the Minister, already discussed with 91. The question is that a new section be there and inserted. Minister to move.
I move.
Is that agreed? Agreed. Amendment number 94 in the name of the Minister, it's a new section, already discussed with 91. Minister to move.
I move.
The question is that a new section be there and inserted. Is that agreed?
Agreed.
Agreed. Amendment number 95 is a new section already discussed with 91. Minister to move.
I move.
That the question is that a new section be there and inserted. Is that agreed?
Agreed.
Amendment number 96 in the name of the Minister, it's a new section already discussed with 91. Minister to move.
I move.
The question is that a new section be there and inserted. Is that agreed?
Agreed.
Amendment number 97 in the name of the Minister, it's a new section already discussed with 91. The question is that a new section. Minister to move, sorry.
I move.
The question is a new section be there and inserted. Is that agreed?
Agreed.
Agreed. With the consent of colleagues and the Minister, I would now propose we suspend until 2:30. We've come to a kind of a natural conclusion there before we go on to the new section of 98. Is that agreed?
Agreed.
We'll be back in at 2:30, please. Thank you very much.